Good morning, everyone. Welcome to our second day of oral argument here in the Harrisburg courtroom of the Supreme Court of Pennsylvania at our majestic state capitol building. As architect Joseph Houston envisioned this building to be a palace of art, I highly encourage everyone in attendance after your arguments to visit the rotunda, the legislative chambers, and the governor's reception room with an eye toward the beautifully crafted artwork, particularly the famous Violet Oakley murals, which were installed in 1927. Violet Oakley was the first female artist to receive a major public art commission, and she devoted 25 years of her life to this project. Her murals on the evolution of law, which surround this courtroom, are simply spectacular. We also marvel at the 52 million pound terracotta dome above the rotunda, a 1/3 scale model of the Dome of St. Peter's Basilica in Rome, on top of which a 15-foot gilded statue named Commonwealth stands. Houston intentionally placed this courtroom on the 4th floor, with the legislative and executive chambers on the 2nd, both to physically separate and symbolically indicate that the judiciary is an independent and equal branch of government. The courtroom was designed in the Greco-Roman art style as indicated by the Ionic columns and the Greek grille wainscoting, all handcrafted. All the wood in the room, including the bench, is mahogany imported from Belize. I'd also like to draw your attention to the 2-ton bronze chandeliers, unique yet different from one another. Under the main light in each is a statue dedicated to the 4 great lawgivers. To my right are the Hebrew lawgivers. Closest to the bench is Moses, and in the back, King Solomon. To my left are the Greeks. Closest to the bench is Aristotle, and to the back is Solon, the father of democracy. The green and gold stained glass dome, designed by Alfred Godwin, is one of the many domes in the Capitol, but this is the only stained glass dome, and it is only visible from inside the courtroom. The majesty of this courtroom is designed to remind us all of the seriousness and importance of the work we are all here to do. In 1927, when Violet Oakley's murals were revealed, Senator George Wharton Pepper remarked that Oakley's murals would remind the justices of their solemn duty and the advocates to restrain their passions and compel candor, and that these paintings would serve as a silent but convincing witness to those things without which we build in vain. We are privileged to sit in 3 beautiful courtrooms in Philadelphia, Pittsburgh, and here in Harrisburg. Before we begin, I'd like to just note, sadly, that Justice David Wecht will not be joining us for this argument session, as his father, Dr. Cyril Wecht, passed away a few days ago. The court extends its sincere condolences to Justice Wecht and to the entire Wecht family. Justice Wecht will still participate in this session. He has prepared the cases, and he will later watch the videos of your arguments. Counsel, before we hear the first case, let me just remind you of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. You may then begin by stating your name and the party you represent and introducing your co-counsel to the court. The justices are familiar with your cases, so I ask that you avoid any unnecessary recitation of facts or procedural history, and instead focus on the main issues on which we granted review. Counsel is always welcome to rely on their briefs for particular issues. Please remember that we do not allow rebuttal. In cases in which there are multiple parties represented by separate counsel, you should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when they are asking you a question. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues which we wish to explore further. While there's no set time limit for argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case.
Commonwealth of Pennsylvania versus Jason representing Commonwealth, Ms. Marissa Booth, representing Mr. Lear, Mr. James Warren.
In this appeal by allowance, we must determine whether for purposes of a defendant's motion to dismiss filed pursuant to Rule 600D of the Pennsylvania Rules of Criminal Procedure, a trial court must assess the Commonwealth's due diligence for periods of delay caused by a suspension of jury trials during the worldwide COVID-19 pandemic. Good morning.
Good morning. May it please the court, Marissa Booth on behalf of the Commonwealth. I visited this building as part of my 4th grade class field trip, and I think 10-year-old me would be shocked that I'm here today, partially because she wanted to be a pharmacist, but also because of the circumstances of this case. COVID-19 was an unprecedented, uncertain, and frankly scary time. There were smaller effects like not being able to find items at the grocery store or not being able to get your hair cut. But there were lasting effects too, like being forced to miss the graduations, births, and funerals of loved ones. But now we know, because of COVID, there is always the possibility of some black swan event, force majeure, or some other unknown. When it comes to Rule 600 and emergencies, there are 2 rules that give this court the ability and flexibility to make it clear that during COVID-19, safety was the top priority and ensure that safety will remain the top priority in any judicial emergency moving forward. The first is Pennsylvania Rule of Judicial Administration 1952, and the second is Rule 600 itself. Under Rule 1952, this court and president judges have the ability to declare judicial emergencies, which then give them the power to issue orders that modify or suspend statewide and local rules, close courthouse facilities, and take any other action necessary to protect court users, court personnel, and the public. In March of 2020, this court declared a statewide judicial emergency and gave president judges the ability to do the same. In Montgomery County, President Judge Del Ricci declared a judicial emergency. Actually, his first one was on March 12, 2020, because he was the first county to petition this court for that ability. But after the statewide judicial emergency, he again declared a judicial emergency on March 16th. After that point, he issued multiple orders governing courthouse closures, county facility operations, and other restrictions that were in place for the public safety. Based on the plain language in the declarations and orders, Montgomery County's blanket suspension of Rule 600 was in effect until August 31st, 2021.
Was Rule 600 actually suspended by the orders? I thought there was other language in the order. I mean, some of the orders that passed our desks during the judicial emergency, the PJs actually said they were suspending Rule 600. Others did not. What did this do?
The orders, there was one order that also suspended the rule. So most of the suspensions were in the declarations from March 16th, March 31st, and then in an order on June 3rd, my position is that the June 3rd order was also enough to effectively suspend the rule.
Well, what does that mean, your position is? What did the order say?
So the order said that delay in scheduling caused by the judicial emergency shall be considered a court postponement and shall be considered and shall be excluded. So that shall be excluded language, shall means mandatory. And in this court's suspensions of Rule 600, it explained that the purport of a suspension is at the time shall be excluded. So that June 3rd order also suspended the rule because it ordered that the time shall be excluded.
If the delay was attributable to the judicial emergency.
Correct. So in this case, the lower court found that the delay in this case was caused by the pandemic, the backlog, the judicial emergency, and then under that order, it was required to exclude it.
Could you give me an idea of what was going on in the courthouse during the period of time that we're talking about? Were there no non-jury criminal trials
Correct.
going on? None.
Correct.
For how long?
So the jury trials were suspended for 14 or let me check, 15 months, I believe. Sorry, 14 months. Until July of 2021. So
Okay, how about non-jury trials?
non-jury trials were suspended for 7 months.
When did they start? When did the court start hearing non-jury trials?
They started to consider that possibility in October of 2020. So what I mean by that is at that time, there were cases actively awaiting bench trials, jury trials in March of 2020. When COVID hits, everything gets canceled, suspended, and all of those things. So the cases that were awaiting trial in March of 2020 were the priority cases in October of 2020. I believe the trial court found that there were 360 cases actively awaiting trials in October of 2020 that were waiting since pre-pandemic. So then the court in October of 2020,
That's a problem.
correct,
That's a problem.
started moving through those cases, and then it would prioritize incarcerated defendants and defendants who were further along in the process before moving to the complaints that were filed in the middle of the pandemic.
Well, this complaint was filed right at the beginning of the pandemic, correct? There's no problem filing complaints during the pandemic, I guess.
Correct.
That's the point.
Correct. The 3 complaints in this case were filed one in May, June, and July. So that's right in the middle of the pandemic and when this court's statewide emergency was still in effect. In terms of the specifics of Montgomery County, when the courthouse closed in March of 2020, President Judge Del Ricci precluded any staff from going into the courthouse. So at that time, I'll illustrate with an example. At that time, the DA's office was working on desktop computers. None of our processes were set up to be remote, and there really wasn't a reason for us to think they had to be, but the county is in charge of our equipment and things like that. So in March of 2020, we're working on desktop computers. We get an email saying, pack up for 2 weeks, and we'll come back, 2 weeks to flatten the curve, and we'll come back. When that didn't happen, we then had to start working with the county to get things like laptops and set up virtual desktops and secure remote programs to do hearings over the internet, which we had never had to do before. So there was
That was true everywhere in the Commonwealth.
Correct.
That was true on this court.
So there was a bit of a learning curve. So when that first started, there was an adjustment period where cases were still being initiated and they were building into the backlog. Then this court's orders directed the president and judge to focus on what were first called essential functions, but then became critical functions. So that was bail hearings, gagnons, some habeas proceedings, and PFAs, things like that. So during that time, we weren't sitting and doing nothing. We were focusing on the critical functions as directed by this court and our president and judge. So again, there's only so far along that you can get a case before at some point the cancellation of, for example, pretrial conferences, before you could get it to that point, and then that was as far as you could go until things were safe. So in that early point, we were focusing on the critical functions and focusing on moving the cases as far as we could get them. Then,
so, counsel, can you describe for me what you mean by that? Because what you're describing are the non-critical functions of the court, or what you've described as the non-critical functions of the process, don't really impact Rule 600, because Rule 600 is speedy trial, right? So
Right.
We're talking about getting the case to trial. PFAs, VOPs, bail hearings don't necessarily move that case forward. What, if anything, was the Montgomery County District Attorney's Office doing to move cases forward during the period of the declared judicial emergency? I think that's the issue before the court, which is whether or not the Commonwealth is required to show due diligence during the periods where the courts were closed.
So we were focusing on what we could, which was the critical functions, but then we were trying to move the cases as best as we could. But we had to do so under the restrictions and protocols from the president and judge. So we could, for example, do a preliminary hearing very few per week, and on a rotating basis. So we would do the preliminary hearing, and then we would wait for the arraignment. If a defendant didn't waive an arraignment, we would have to wait for that to happen. And with the backlog, there was significant delays in even things like an arraignment because we were working through that. So basically what we were doing is focusing on the critical functions, but then when things came up, we would be prepared and make sure we were prepared to go when we did have that opportunity. In October of 2020, for example, that's when we started, we called them triage conferences, which were basically a pretrial conference and just something to figure out the disposition that the case was going to proceed on. So at that listing is when the attorneys, the parties would figure out, is this going to be a jury trial? Is this going to be a bench trial? Or a plea. Once we knew that, it would get moved into the appropriate bucket behind, of course, all the cases that were already there.
While all this was going on, Judge Del Ritchie's order suspended Rule 600, did it not?
Correct.
So you're acting under a suspension
Correct.
order?
So,
And no trials are going on at all?
correct.
Is that correct? I mean, I'm going to get back to my original question. The order did not suspend Rule 600. The order said that delays attributable to the judicial emergency are to be excluded. I mean, that's really two different things. Some orders did, in fact, suspend Rule 600. Our original order suspended Rule 600. Many of the orders that we saw from other PJs across the state actually said Rule 600 is suspended. That's not what this did.
So our Rule 600 was suspended. The Superior Court reviewed that May 5th order to find that our blanket suspension ended on May 31st, 2020. That May 5th order acknowledged that there were both declarations and orders, and then suspended only the orders. In the declarations, the language is that Rule 600 is suspended during the period of the judicial emergency. So our belief in what we operated under is that those declarations suspended the rule for the period of the judicial emergency. Then in the June 3rd order, which said something like delays in scheduling caused by the judicial emergency shall be excluded. Shall be excluded is mandatory. So again, we thought that was another...
But what does that mean? Does that mean you just stopped working?
No.
Well, see, that's the point.
That means...
I'm a little bit, it takes me back a little bit because I would think that your position would be we use due diligence under the circumstances, as opposed to fighting the notion that you have to establish due diligence. I mean, you guys weren't sitting on your hands for 8 months,
Right.
9 months.
And you could argue both.
Right.
Truly, yeah. I mean, that's why it just strikes me as being odd, because sort of bottom line on what you're suggesting is we didn't have to do anything, and that can't be. I mean, all of you were working. I mean, there were bench trials taking place during this time, and ultimately, this defendant had a bench trial, not a jury trial.
Correct.
And that decision is usually made because the case is moving along and you get to the point where it's going to be tried, and that's where the defendant would opt for a non-jury trial. So I just don't, I don't understand the position, if it is your position, that we didn't have to do anything during this time period. Is that your position?
I think that's part of my position, because I think in a pandemic that is leading to many hospitalizations and deaths, sometimes what you have to do when it's a public health crisis is nothing. It is sit at home. We didn't do that, and we did our best under the circumstances, but part of the issue and why we're here is because we don't have standards for what due diligence means in a pandemic. And cases have been dismissed because we don't have that. What has been happening in the lower courts is that they're applying the usual due diligence standards. So are you filing the bills? Is discovery complete? Are you trial ready? During the pandemic, with the backlog building based on the restrictions that were in place, for example, those triage conferences, when those first started in October of 2020, it wasn't that every judge then had a triage conference. It was 12 triage conferences a day with one judge. So yes, they resumed, but when everything started to pick back up, there were severe limitations still in place. So due diligence during that time, we need guidance on what that means. I spent a lot of time thinking about this, and early on my answer was, I have no idea what reasonable efforts or due diligence means in the context of a pandemic where the governor is telling you to stay home. I do not.
But that ended. I mean, that did not go on throughout the entire period of time that we're talking about here.
Correct. But we still had limitations from the president judge, many of them. And we did try to ask to resume different things sooner, and that was just not an option for Montgomery County, which Montgomery County was dubbed the epicenter of the pandemic in Pennsylvania. When it hit, we happened to have a medical doctor chairing our commissioners. So we did our best to respond, but we had many restrictions in place that were meant to protect the public. And in that respect, if you apply normal due diligence standards to this case, for example, passing discovery, things like that, when COVID hit, we had desktop computers and no remote operations. The only way to compile and pass discovery would have been to go to the office. What that would have meant is violating our president judge's orders, keeping us from the office. When the pandemic first hit, we were allowed to have 4 people out of more than 50 in our office. 4 out of that many people. So we had a choice to either violate those orders and try to go in, but there's an issue with that because part of it was that we had to give the sheriffs a list of who was actually allowed in our office that day. If you were not on the list, they did not let you in.
Could I stop you there? Did the district attorney's office have a policy as to how it was going to define due diligence under this pandemic? Was that a matter for discussion and guidance from your superiors?
We didn't have a formal policy. We were instructed to do our best, keep our cases prepped and ready to go for when they did get called in. But it was pretty much just stay safe. This is what the president judge is telling us to do. We're going to do that. And I think we were operating under the belief that 600 was suspended. So I think if we knew that a year and a half later the Superior Court would come in and say that it wasn't suspended, we would have done things differently. But even if we made that choice, the first choice is to try to violate the emergency orders that were meant to protect us and the public and everyone in the courthouse. Assuming we made the choice to ignore the order, we could get past the sheriffs, we would make it into the office, then you could only get it again so far along before you would just be waiting for it to be scheduled, which again happened in as directed by the president judge with court administration. So you would make the choice to violate all those orders, and then you could still only get your case so far along.
What seems the bottom line is that you need to demonstrate that if we determine your due diligence was required, that you exercised reasonable due diligence under the circumstances.
And correct. And I think after I've spent now over a year thinking about what that means, where I landed is this. Due diligence during a judicial emergency, especially one that's based on health concerns for everyone in the state, due diligence in that case means complying with orders from your president judge, complying with orders from this court, complying with orders from the governor. I would submit that that is reasonable efforts. I think that's the most effort you can do unless you want to pick a fight with your president judge or the county that you work for.
Well, that makes sense on one hand, but on the other hand, the due diligence we're concerned with is not just the general due diligence of the office, but the due diligence in moving cases forward.
Right.
Counsel, I have a question.
Wait, could I just get an answer to that?
I thought that was a comment. I'm sorry.
That's right. Does that change your calculus at all when you focus on that definition of due diligence?
Sorry, can you repeat the first part of that?
Sure. You were explaining your due diligence as an office, the things that you did in your office. My question was, with respect to the focus of this case, due diligence in moving cases forward, that would come under a Rule 600 analysis. Does your argument change?
I don't think so. This case I think is a good example of a case where we obviously took steps to move it along because within a few months after the run date, the mechanical run date, not the adjusted run date, within a few months, on 3 weeks' notice, we coordinated over 40 witnesses, proceeded to a 3-day bench trial on over 70 charges, and introduced over 200 exhibits. We couldn't have done all that with 3 weeks' notice if we weren't doing things during the pandemic. But I also recognize, and we're here because not every case is that fact pattern. We do have cases where there might be 7 months in between a preliminary arraignment and the ultimate pretrial conference or triage date. I don't know how to explain that other than we were prioritizing the cases as directed by the president judge and essentially just waiting for, under the process that court administration used, waiting for the docket to be reached. So it's those time periods that under normal circumstances, just waiting on the court administration isn't necessarily due diligence. So without something saying that following what the president judge tells you, or it is reasonable efforts to just let court administration do its best to work through the backlog, the normal due diligence standards are going to result in cases being dismissed, and they have. So I think even in terms of due diligence, when it comes to an emergency that everyone knows caused a backlog, we might also need something that says, as long as court administration has some reasonable method of moving cases along, us prioritizing the cases that are going to come up first isn't a lack of diligence in terms of the other cases. It's knowing that certain cases are going to be reached, prioritizing those first, and then moving along. But when you do have a backlog, I believe the numbers, pre-pandemic, there were in the 4,000 or so active cases. With the backlog and the emergency restrictions and all of those things, our backlog went up to over 9,000 active cases. We didn't get double the attorneys, but we had double the cases. So we prioritized what was coming up first, and those are all reasonable efforts. But that, under traditional due diligence standards, that isn't necessarily due diligence, just waiting for your cases to get called. So we really need guidance from this court for everyone in the state, because other counties did use similar language to the court postponement shall be excluded language. So we need guidance that recognizes this was a scary time and everybody was doing their best. We trusted our president judge, who trusted I believe the language is wide authority or substantial discretion under Rule 1952 that this court gave him. And he exercised that, and we didn't question anything he did because we knew this is about safety, this is about protecting the public.
Counsel, I keep getting back to this point, and you know, honestly, I think this is a tough question because we were responsible for allowing president judges to do what happened during the pandemic. So sort of the buck stops here with that. But there's one thing to declare a judicial emergency, and that, of course, impacts entrance into the courthouse and jury trials and things of that nature, which is distinct from what the district attorney's office can or should be doing in terms of moving cases along to the best of the DA's ability. And I keep getting back to that because, to me, they are really two different things. Different counties handle this very differently, and I know we don't have an equal protection argument before us here, but you know, defendants in different counties ended up in very different situations as a result of this. But why is it that I'm going to ask again, are you saying that there was no due diligence duty during the judicial emergency, period? In other words, you could sit on your hands for 11 months because there was a declaration of a judicial emergency?
Yes, I am saying that. However, I would note there is no incentive to do that because when the emergency ends, our cases are coming back. So there's no incentive for us to sit there and do nothing. We weren't doing nothing because we were prioritizing our critical functions. And there's also the constitutional speedy trial analysis. So it's not that defendants are left unprotected by us complying with the president judge's orders. They can still raise constitutional speedy trial claims, which would then consider the length of the entire delay. So it's not, while yes, I think when a president judge under a judicial emergency exercises emergency powers and suspends a rule, I think, yeah, we technically could sit and do nothing. However, we didn't. I don't know that any office ever really would, but this has to be flexible because any other interpretation is dangerous.
Commonwealth, during this time period, were you collecting discovery, or were the various police departments throughout the county providing the necessary discovery?
Yes, eventually. Again, when we first started, we didn't have remote or any operations for discovery like that. It took time to we eventually got those in place. It took time to do so.
But during this time period, the Commonwealth you were requesting discovery from the various police departments.
Correct.
Despite the fact, I mean, going to Justice Donohue's question, you guys, in fact, still attempted to pursue the prosecution by seeking the necessary discovery during this time period that you weren't allowed into the courtroom.
Correct.
Okay.
And eventually we were allowed 8 people in our office.
So, Ms. Booth, I'm just trying to, what is it you're asking? Justice Donohue keeps coming back to the same point, and you're kind of dancing around it. We're the Supreme Court, right? So we have to fashion a rule that is going to be applicable to every county in the Commonwealth of Pennsylvania. So are you suggesting a blanket rule that for whatever time that the court issued an emergency motion, that the Commonwealth doesn't have to show due diligence? Or are you suggesting, which I think you're suggesting in response to Justice Donohue and Justice Doherty's questioning, that this really requires a case-by-case analysis, no different than Harth or Carl? Because if you recall, in those particular cases, and all I could think of is, and I think Justice Doherty wrote the dissent in Harth, but you come out of a pandemic, right? And then the first listing for the trial, you say, we don't have discovery, so we need another 3 months. Well, did that show due diligence? We're not readying our witnesses because we've had no conversations with our witnesses. Is that due diligence? So are you looking for us to kind of fashion a blanket rule, or are you saying that this should really be a case-by-case analysis to determine due diligence?
I think the answer to that question is both, and I'll explain.
You're dancing around my question.
I'll explain. So I think the general rule needs to be that delay, all courts, all parties, everyone agrees.
But again, how can it be both? Because if you give me a blanket, okay, in a case of judicial emergencies, you don't have to do anything. If you come out of a judicial emergency and you're not ready on the first listing of the case, how can you say with a straight face, Judge, we showed due diligence?
Okay. So the blanket rule, I'll start there and then I'll move to when we come out of the pandemic, if that's okay. The blanket rule needs to be that judicial delay caused by, or a judicial delay caused by judicial emergency is excluded without the need for the lower court to assess due diligence. If we go beyond that, and I don't necessarily think that you need to, but I understand we need guidance. So how this will work is that this court allowed president judges to suspend the rule until August 31st, 2021. That time period is excluded, period. No need to assess due diligence.
What I'm saying is there should be a presumption of excludability unless and until the Commonwealth has shown that they're not ready.
For that time period, it's excluded, period. So September 1st, 2021, we come back.
You want the time clock to begin running again as soon as the case is listed for trial, as opposed to what happened in Harth.
Yes, I think once we hit September of 2021, it looks more of like a traditional analysis. For example, if the hypothetical is that we come back and 3 months later, that's the first triage conference. If at that conference, the Commonwealth says, we need more time to do X, Y, Z, that's when you look at, for that 3-month period, were we duly diligent? That's a relevant, Harth talks about relevant time periods. So that time period, if the Commonwealth was not making efforts to complete discovery or move this case along, that time still counts.
But really, shouldn't we expect more than that? Shouldn't we expect the district attorneys to say, well, yes, we weren't able to exercise the normal degree of due diligence, but even though there was a suspension of Rule 600, we did what we could. We exercised what was reasonable due diligence during that period. You're arguing you don't even need to do that.
During the judicial emergency, correct. I don't think we need to do that. Our president judge had directions from this court. Once we get back, I think our diligence comes back into play. And during that time period, we would have, but here's the thing, if we weren't making efforts during the pandemic, we wouldn't be able to show it soon after.
Well, let me go back to this particular case, although we're going to render a decision that impacts the whole Commonwealth, but with respect to this case, Is it your position that, I know it's your position you didn't need to, but is it your position that the Commonwealth did exercise due diligence as was reasonable during the pandemic on this case?
Yes. Discovery was...
Gratuitously, apparently.
Yes.
but- Okay.
Discovery was complete. Cases were joined timely. We filed the bills. We proceeded. The bench trial happened shortly after we came back. But I know not every case is like that. And I agree with you that, you know, maybe as long as we can show that we make reasonable efforts, we're fine. But that's not the standard that the lower courts currently have. All they have is the normal due diligence stuff, where if your bills weren't filed within a few months, that's a sign that you weren't duly diligent. During COVID, we have many cases where our bills might not have been filed for 8 months or more. So I think if you want to go that route, we need guidance in that respect too, that, look, this was a scary, unprecedented time, and due diligence in this case isn't filing bills within 2 months of the case coming up or getting the formal arraignment within 2 months of that. It's reasonable efforts, complying with the orders and things like that. But that's the issue. Because we don't have that, cases are being dismissed. So I think no matter which way we go, we definitely need guidance. And I would submit, though, that under the plain text of Rule 600, delays caused by the Commonwealth when it has failed to exercise due diligence are included. Any other period of delay is excluded. So in Commonwealth versus Johnson, this court explained that that meant there were 2 requirements for delay to be included, that it's caused by the Commonwealth and the Commonwealth has failed to exercise due diligence. The next sentence said something like, if the Commonwealth did not cause the delay, or they did but they were duly diligent, it's excluded. This is a case that all parties and all courts agree was not caused by the Commonwealth. There has never been anybody to say that it was caused by the Commonwealth or that anything we did or didn't do delayed this trial. So in this case, and many others like it, when there's a finding from the lower court that a backlog in the judicial response caused the delay, Rule 600C1 comes in and excludes that as an other period of delay.
Okay, I think we understand your position. Do any of the justices have any further questions? All right, thank you. Let's hear from your opposing counsel.
Good morning, Madam Chief Justice, fellow justices. If it pleases the court, I'm James Brodnelli on behalf of Appellee Jason Lear. I guess let me start by saying I don't think anyone disputes, and certainly the defense does not, that the pandemic wasn't a very difficult, very trying time, or that can't be a factor to be weighed by the court in assessing due diligence. Just as this court's emergency orders indicated it could be a factor in assessing compliance with speedy trial rights. If your discovery was a month late because your assigned investigator was in the hospital with COVID, or if you couldn't get to your computer, those are all things you can recognize. Inherent in due diligence, I think, is reasonableness. What is it reasonable to expect the Commonwealth to do under these circumstances? And obviously that's going to change from a worldwide pandemic to today, where everything's running smoothly. But that doesn't mean you throw the baby out with the bathwater and in essence find that the pandemic amounted to a due diligence free card, a 15-month one, in which even if the prosecutor just sat and watched Game of Thrones reruns for the whole time, that somehow that's still okay. But that's really what the Commonwealth argues. And with respect to this individual case, why I think remand was appropriate by the Superior Court is there's really not a record as to what the Commonwealth did here. They may have been due diligent, we don't know. That's because what you would normally expect at a Rule 600 hearing.
How would you expect the Commonwealth to memorialize their due diligence if historically it's based upon the court, the record, and the comments written in our court files? If all that is suspended by order of President Judge Del Ricci, how does the Commonwealth show it?
I think at the Rule 600 hearing, you make a record. You show this is when discovery was requested. This is the email where we sent it. this is the emails or whatever requests we made of court administration to try to list this thing faster. Mr. Lear was arrested initially in May 19th of 2020. The Montgomery County began its, quote, triage process where you could request a waiver trial or a plea in August of 2020. Mr. Lear didn't get a triage conference until August of 2021. So I think what you would normally would expect is once October 2021 rolled around and we had a Rule 600 hearing, that you would again offer evidence supporting what you were doing during that time.
Was Mr. Lear in or out of custody during this time period?
In custody.
Okay.
Yeah. Justice Donahue touched on, and Your Honor just said that Rule 600 was suspended for this entire time. I would differ with that for the reason that Justice Donahue mentioned. And in fact, that is even more apparent when you look at the chronology of emergency orders issued by Judge Del Ricci. His first one, March 16th, which indicated there was a judicial emergency to April 14th, said very clearly, was based on basically the template that this court had issued, and said Rule 600 suspended. He issued another one March 31st, extending it to April 30th. Again, Rule 600 suspended, clear as day.
What about the May 28th order, where he just extends the emergency order till further?
He at that point adopts, actually at that point doesn't adopt it. He adopted it clear back on April 14th. The third order he issued did not use the same language. It instead used the language that any delay caused by the judicial emergency shall be excludable. And I would say inherent is that in that it is really a Harth analysis by any other name. In other words, was this solely due to pandemic delay, or is there some showing of lack of due diligence that it can be attributed to instead? And I think inherent in any rule, most basic rule of interpretation, be it statutory interpretation here, judicial order interpretation, is when someone changes the language on something, they do it for a reason. And I think the reason here is very apparent. When Judge Del Ricci issued the April 14th order at that point, the statewide suspension only went to April 30th. His order was extending it beyond that date by a full month, clear till June 1st. And I think he wanted to tread lightly and not completely suspend Rule 600, especially given the length of time. I think that was again his reasoning on the June 3rd order that Justice Dougherty mentioned, which was indefinite. It's one thing to suspend Rule 600 for 2 weeks. It's another to say that the Commonwealth has to exercise no diligence for an indefinite period of time, and it ended up being 15 months.
So you're suggesting that there should not be a blanket rule, and this should be a case-by-case analysis like Harth.
Exactly. You look at what was done. Was it reasonable? You can certainly factor in.
Let me back you up.
Pardon me?
Let me back you up.
Sure.
Justice Dougherty just asked you a question. During the period of 90 days, or just say for the sake of argument, there's a 90-day suspension order in effect, or 9 months, whatever it is. What does due diligence look like?
I would argue.
The reason I asked you that question is, Harth is a case, if you recall, there was a delay. It came out of the delay, and then the first listing, the Commonwealth said, we're not ready, we didn't complete discovery, we didn't contact our witnesses. And the judge said, wait a minute, we've been doing for the last 6 or 9 months, threw it back for a due diligence analysis to answer that question. In this particular case, what are you suggesting the Commonwealth has to show during the periods where, in this instance, courts are closed?
I would argue first, they need to show, and the court has previously in the Edwards-Hawk line of cases indicated there needs to be some efforts to move the case along. I understand there was a huge backlog, and again, but at least you're making the request. And if you're told no, we can't accommodate that, you tried. More importantly, you also have your discovery obligations that I think.
But then you make the argument that this is caused by the courts. It's court delay, and therefore it's not excludable. Remember back in the day when you were in the Philadelphia DA's office and you would ask for or defense attorney would ask for a continuance? The first thing you would ask the trial judge is, Judge, time rolled excludable?
Right.
And it would be a notation to Justice Dougherty's point. There would be a notation on the file for the appellate court to say, well, that's excludable time, what we would sometimes call extendable time. There would be an
Correct.
on-the-record determination. But where courts are closed, how do you make that determination?
I think it can be documented, and certainly could even be done via testimony of the DA assigned to the case, that I made these requests. They couldn't be accommodated. Here is when I passed discovery. Here is when it was requested. Here is when I requested the earliest possible date, which is another thing we always had to do back when I was a DA and at the time the case was continued. You document those things. There's no record of that here, largely because at the Rule 600 hearing, the defense, Rule 600 motion alleged 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 different averments alleging lack of diligence, one of them alleging lack of due diligence providing discovery, and it rested on that. That should have really turned to the Commonwealth then at that point to bear the burden to put some sort of evidence, via documentary evidence or testimony or what have you, establishing the efforts that they made. Instead, they just rested on their pleadings, but their pleadings basically were the same argument they're making today, that we don't need to do anything. It's suspended.
At least they're consistent.
Pardon me, Your?
At least they're consistent.
Yes, they're at least consistent. So I think, one, certainly from June 3rd on, Rule 600 wasn't, quote, suspended. What they were required was to show due diligence, which is why I think the Superior Court properly remanded this matter. Just another thing I think it's important to note, the Commonwealth didn't touch on it here, but in its brief, it asserts that Harth never applied to system-wide delay. I think that's an incorrect reading of Harth. One of the big chunks of time in Harth was actually the papal visit to Philadelphia. I know two members of the court were on the First District bench at the time, and you'll be glad to correct me if I'm wrong, but in other words, that shut down the entire Philadelphia court system. In fact, it shut down all of Center City, Philadelphia, people playing Frisbee in the middle of Broad Street and all sorts of stuff. So Harth in and of itself deals with the types of, system-wide delays that we're dealing with here. This is on a much grander scale for a much longer period of time. But I think that's really the beauty of Harth, is it factors those things in. That's what due diligence is. It's reasonableness. What efforts were you making? But you have to show you were making reasonable efforts.
So let me ask you this question, because this is something that's long kind of germinated in the back of my mind. Is there a corresponding obligation on the part of the defendant? Rule 600 is a successor to Rule 1100, right? It's an order that's basically, it's a rule that's codifying a speedy trial, a constitutional right to a speedy trial. I'm thinking, what if the defense attorney doesn't do anything to contact court administration to move the case forward? Are we looking at an ineffective assistance of counsel claim? Should there be a corresponding obligation? Because you're saying Commonwealth's got to be due diligent. Commonwealth's got to move this case forward. Commonwealth has to ask for a date earlier than the run date. Doesn't the defendant have the same obligation, or defense attorney? Or shouldn't they?
As with so many things in the criminal justice system, Justice McCaffrey, I think the burden lies with the Commonwealth. The defendant is the one who is sitting in prison. If you want to keep him there and you want to try him, it's incumbent upon the Commonwealth to comply and make their reasonable efforts to try to get him to trial. I always said a criminal defendant is sort of like a groom at a wedding. Your only obligation is to show up. I think that's much the same here. You are correct in terms of a Barker v. Wingo analysis, speedy trial rights, then how quickly you assert the right is a factor that they can consider, but that's not the case under Rule 600. That's not what the language indicates. So I don't know that it's really incumbent on the defendant to do that.
May I ask a question?
Sure.
Is there a question in the lower courts about the concept of reasonableness in this due diligence analysis? Because certainly the circumstances of the pandemic is something that would have to be taken into account. Do you not agree?
Absolutely.
In analyzing due diligence? Do you perceive a misunderstanding on the part of the lower courts in terms of adding that reasonableness concept into due diligence?
There seems to be the two major published opinions, Carl and this case, indicate, but they deal with different orders. Carl, of course, has the blanket Rule 600 suspension, whereas Lear here, I think, does recognize the reasonableness. The thing is, I think they wisely, and we did not challenge this at all, said that based on the record we have here, we can't make that determination. What we need is to have this sent back and see if the Commonwealth, when given the chance, can establish that they were making those reasonable efforts.
In the context of the emergency
Of course.
order.
Yeah, correct. I mean, normally if your bills are drafted in 30 days after arraignment, but they were drafted in 60 here because no one could get to a computer because the office was closed, of course, that's something that you can factor in. It's another to show that no one did anything. The latter, I think, would clearly, be a breach of the due diligence requirement that Hearth imposes in Rule 600. And just one other thing I would note, I mean, the Commonwealth indicates cases are being thrown out. I have to say, at least for our office in Montgomery County, Lear has been the law now since February 23rd, I think, of 2023. And in that time, it's been binding on the trial court. There hasn't been some sort of apocalyptic emptying of the jails or anything like that. There's only been one case that our office has won on a Rule 600 motion in that time under Lear, and it was sort of a comedy of errors where there really was just short of watching Game of Thrones reruns the whole time. The other time, the Commonwealth, I'm glad to say as a citizen, was doing its job. And they've been able to show this is what we were doing, this is the efforts we were making. And I think that's the appropriate remedy here, is to send this back and to see if they were duly diligent. How the court ultimately arrives at that question is really what will have a system-wide effect here. It's one thing to say, yes, this is a very trying time. It can be certainly considered. On the other hand, to neuter Hearth in the way the Commonwealth asks, because what they're really asking for is anything short of just, congested calendars that somehow the due diligence requirement is out the window.
Well, isn't it really, and we went through a really difficult time, and in all fairness, I'm troubled by this case only because it was our court that issued an order to say, we suspend Rule 600. We didn't say, we suspend Rule 600, but we still expect you to exercise due diligence. And when we allowed the trial courts to issue their emergency orders, we delegated it to them to find out what was necessary to keep their residents and court users safe. And these orders never said, they said we suspend Rule 600 or we exclude the time under Rule 600, but never did any of those orders say to the Commonwealth, but we still expect you to exercise and document your due diligence. So now it's always 50-50 looking back, or 100% view when you're looking back through the window of time. And I feel a little bit unfair to the Commonwealth, because from what the advocate for the Commonwealth's office argued here today, they did do their best to exercise due diligence, despite the fact that none of their orders requested or required them to do so.
I think first, it's important to note that the blanket suspension you're referring to in your orders basically ended on June 1st. So for only 12 days of Mr. Lear's incarceration was the blanket suspension in effect. After that, the only thing in effect was Judge Del Ritchie's order. And again, I think they were on notice, quite frankly, given the change in the language from the original two emergency declarations to the third one and the fourth one, which no longer said Rule 600 suspended. It instead said delays caused by the judicial emergency. I think at that point they should have been on notice that we have to comply with our due diligence requirements. And the other thing is, again, counsel's made quite a few assertions here, but I think it needs to be a case-specific thing, not we were doing this as an office-wide. What did you do for Jason Lear? And that can only really be addressed in a hearing on remand, which is why I think the Superior Court should be affirmed here. Thank you.
Before we call the next case, Mr. Minner, I'd like to welcome some students who are with us today. We have the Lower Dauphin High School Youth and Government Club Judicial Branch, which indicates that they have 3 branches to their Youth and Government Club. I'd like to ask them to stand so that the court may recognize them. Thank you for being here. Hopefully we have some future lawyers in that group. These students are here at the invitation of Justice Donahue, but I would remind you all that we always welcome students, high school, college, and law students, so please encourage your classes and clubs to come and visit us in our 3 courtrooms. We're always delighted to see you. Mr. Minner, would you call the next case?
County of Northumberland versus the Township of Cole. Representing the Township, Mr. Michael Winfield. Representing the County, Mr. Frank Garrett.
In this appeal by allowance, we are asked to determine whether under Section 1A of the Refund Act, the County of Northumberland was required to submit a written and verified claim with the Township of Cole for a refund of payments it made to the township before the county could file an assumpsit action in the trial court. Good morning.
Good morning, Chief Justice, fellow justices. May it please the court. My name is Michael Winfield, and I'm here on behalf of the Township of Cole. As outlined by the Chief Justice, this case invariably involves the interpretation of a statute. And this court is well versed in what that requires. There's probably no better established body of jurisprudence than that interpreting statutes in this Commonwealth. The Statutory Construction Act is the guidepost for the interpretation of statutes. This court has issued hundreds of opinions over the years regarding the application of that statute. And in fact, 3 decisions have already been issued this year. Yesterday, you heard a case, the first case out of the gate was on the Statutory Construction Act. What's consistent with almost all of your opinions that come forth is how the case is set up in terms of the analysis. And I want to refer to a decision that was issued this year in 2024, authored by Justice Brobson, that dealt with the Statutory Construction Act.
That's dangerous.
Yes.
They all start out similarly in saying that we are guided in our analysis by the Statutory Construction Act of 1972, which provides that the object of all statutory interpretation is to ascertain and effectuate the intention of the General Assembly. Generally, the plain language of the statute provides the best indication of legislative intent. If the statutory language is clear and unambiguous in setting forth the intent of the General Assembly, then we cannot disregard the letter of the statute under the pretext of pursuing its spirit. In this vein, we should not insert words into a statute that are plainly not there. When the statutory language is ambiguous, however, we may ascertain the General Assembly's intent by considering the factors set forth in the Statutory Construction Act and other rules of statutory construction. Moreover, words and phrases shall be construed according to rules of grammar and according to their common and approved usage, though technical words and phrases and such others have acquired a peculiar and appropriate meaning or are defined in the Statutory Construction Act, shall be construed according to such particular and appropriate meaning or definition. We also presume that the General Assembly does not intend a result that is absurd, impossible of execution, or unreasonable, and that the General Assembly intends the entire statute to be effective and certain. That's generally the language that is used in all of your decisions. What's noteworthy here is even though this was a case involving the interpretation of a statute, none of the lower courts ever referenced the Statutory Construction Act, nor did they follow this analysis in reaching their decision. What the lower court did is took a statute which contains certain specified steps to effectuate a remedy conveyed by the legislature and excised one of the requirements set forth in those steps. And they did it without referencing that the statute was ambiguous. They did it without referencing a justification under the Statutory Construction Act. They did it in violation, really, of the principles that have been established over and over and over again. And the core of those principles, and I'm struck by something that Chief Justice Todd said at the very beginning today, and that this court was placed on this floor, right, as an example of the separation between this body and this branch and the legislative branch. And that's really at the core and the essence of the Statutory Construction Act. It's to recognize the distinctions and the roles of the various branches. And it's not for this court to legislate, and it's not for the legislature to adjudicate. And so the Statutory Construction Act provides us our map. It provides us how we go through and analyze when we have a statute to interpret it. Here,
Counsel, if I might.
yes.
What would this verified request look like in your mind?
Well, verification is
I know
specifically
let's
defined.
say,
Requires oath and
I
affirmation.
swear that what?
I swear that the facts set forth in the following claim are true and correct to the best of my knowledge, information, and belief subject
Okay,
to...
now here's the problem I have with that. The County of Northumberland asked Cole Township for a specification of the actual costs that were incurred in the permit inspection. They got no response. Now, had there been a response to that, I understand your point. Then they could say, we hereby make demand for $107,000, which is the excess of the amount charged versus that which were the actual costs. But they got no response to that. So as I'm seeing this situation as it's presented to us, what you anticipated was a letter that says, we swear that we are demanding payment of excess costs, period. What does that tell you? What does that tell your client in terms of the specificity that I would expect to see in a claim that's verified? It seems to me that they couldn't do what you're asking them to do because they never got a response to their request for information regarding actual costs. Am I missing something in the the way this played out?
Actually, Justice, I believe you are, and that is they were able to file a complaint in assumption and attach a verification to it. And they moved forward in doing so, right? So the ability to verify was there. What you're talking about is what are you verifying? But what we're talking about here is the ability to verify. They still put forth a complaint. They still made a request for a refund, and they did it with a verification attached to it in the complaint. So they could have.
3 years. And they did it within 3 years, which is...
No. And that's what gets to the heart, and I think it's important, and you're zeroing in on the point, and the point is to take a look at the statute and what the statute provides and what's intended to provide. Is it a notice statute and only a notice statute? In order to determine that, we have to read the text of the statute. And we have to look at the statute in conjunction with the history behind what its purpose is. And the history, as the Aronson case and as Stranahan point out, is at common law, someone who paid a tax under protest or paid a fee under protest to a public entity or a political subdivision did not have a right to a refund. It didn't exist. It didn't exist. And so this act was passed in order to convey that right. So now it created a right and a remedy, and in doing so, it set forth a process and a procedure to follow. And that process and procedure...
Your whole issue here is that the verification that was on this particular letter doesn't satisfy the Statutory Construction Act. You've used that term now 3 or 4 times, Statutory Construction Act. The Statutory Construction Act doesn't define verified, but you're, in response to Justice Donohue's question, you're actually asking us to insert an additional requirement in the Statutory Construction Act in accordance with Section 4904 regarding unsworn falsifications.
Actually, no, I'm not, Your Honor, or Justice McCaffrey. The Statutory Construction Act actually does provide a definition for verified.
But you're asking us to say that what was sent in this particular letter. In other words, when I was elected judge, they give you a little stamp, right? Mm-hmm. And I was under the impression when I first got elected judge that the stamp had to be on everything I signed. But then I was told, you know what? When you sign something in your official capacity as a judge, your signature is the verification. Your signature is all that's required. In this particular case, you have an elected or an appointed official on behalf of the county who sends a letter saying we dispute that we have to pay these particular things, asking for the backup information, and you're saying that doesn't constitute a verification. Should they have put a little stamp on the bottom? Should they have signed it under subject to unsworn falsifications? Why doesn't that signature of an official, an elected or appointed official in their official capacity, satisfy the verification requirement?
Because the Statutory Construction Act defines verified as it relates to a writing as being under oath or affirmation. It defines it. And it's not up to this court to question why it defined it that way. It's not up to this court to erase that requirement. There are all kinds of notice requirements. There are all kinds of requirements that the legislature puts on parties, that puts on citizens in order to do stuff. And verification is a very specific one. It's not very commonly used. We don't see that all the time. There had to be a reason that the legislature chose it. It's not ambiguous because it is defined in the Act. It would be ambiguous potentially, Justice McCaffrey, maybe it would be ambiguous if they didn't supply definition. But the Statutory Construction Act actually supplies the definition. And under the provisions of the Statutory Construction Act, when the Statutory Construction Act provides a definition that's of a term that's used in a statute that's not defined in the statute, that is the definition that is to apply.
Okay, counsel, let me ask you this question. Would it satisfy you if the letter that they sent had a statement on the bottom that said, this demand for a refund is made subject to penalties of perjury? We demand a refund, period. Underneath that it says, we certify that this refund demand is made under penalty of perjury.
That would have satisfied the verified component. Certainly would have satisfied the verified component. Whether that in of itself would satisfy the claim component, that's not before this court.
Well, why isn't it?
Well, it wasn't part of what was brought up before this court. But we can certainly talk about that in terms of what constitutes a claim. Is it a claim? If we take a look at the letter, what did the letter actually say? Did the letter say we're demanding a refund? No, it didn't. What did the letter actually say? The letter said, we are requesting information. We don't believe that you have the right to charge us anything above what your costs are. So provide us information. If you don't provide us information, we're filing a lawsuit. It didn't say, we demand in this letter that you repay. It didn't say we repay in the entire amount. It didn't contain any of the things that would satisfy the standard of a claim in the court.
Those issues below for us to review?
I believe certainly it was raised in the record. Certainly it was argued at every level. Certainly it was argued. It wasn't necessarily granted in the questions for review before this court. But I would certainly argue it doesn't even rise to the level of a claim. But you don't even get to the level of the claim if you can't get past the verified.
Well, you don't get to whether it's verified unless it's a claim.
Fair enough.
So I'm trying to, I mean, that jumped out at me, that the letter itself does not request a refund at any point in time.
It does not.
It threatens a lawsuit if you don't provide information. To Justice Donahue's point, it's basically it's almost an allegation that we don't have the information we need to file the claim. Provide us with your explanation as to why you think this is a fee and not a tax. And by the way, if you don't respond, we're going to bring a lawsuit, which seems to be jumping the gun under the statute. Now, this is all very interesting to me, but if it's not here, we can't reverse for any reason. We can affirm for any reason, but you want a reversal. And it doesn't seem to me like you have, maybe, did you ask for us to take that issue and we limited it to the verification?
We asked to take the issue of whether or not the actions of the lower court effectively overruled the Stranahan decision, or implicitly overruled the Stranahan decision because it altered the process and procedure. So actually it actually is before this court in the context of. We didn't brief here in detail that it didn't constitute claim. I believe I referenced in the brief that it doesn't. It's not a claim. But I did not go into detail as to that specific component of it. But it's certainly not verified. And in fact, the whole premise and the whole basis for the Commonwealth Court decision.
It didn't have to be verified.
Well, but if it's not verified, it doesn't meet the statute either. And the basis by which the Commonwealth Court made its decision was in focusing in on the verification and stating that it is undisputed that it was not verified. So what the Commonwealth Court did is the Commonwealth Court teed up and said, this doesn't meet the statute. Whether it was a claim or not, the Commonwealth Court said it doesn't meet the verification.
I think the Commonwealth Court said it was a claim. It seemed like but by the time this got here, it seemed like everybody was assuming that it was a claim. Even the Commonwealth Court seemed to think it was a claim because, I mean, I really doubt the Commonwealth Court would have gone to the verification issue if they didn't think it was a claim. And that's kind of where I'm struggling with is I don't know if this is a case where we should be deciding to what level a claim has to be verified if we don't even have a claim in front of us.
To allow the decision below to stand would allow a lower court decision that did not analyze a statute pursuant to the Statutory Construction Act and basically wrote out a requirement by saying it's undisputed this was not verified, but we're going to provide relief. So what does that set as by way of a precedent from this court? What it establishes is that a lower court can take a look at a requirement and say, I don't have to do statutory construction analysis. I don't have to determine whether this is ambiguous. I can simply say it wasn't met and I don't care. It wasn't met and I'm going to find a way to get to an outcome. That's exactly what statutory construction analysis says you cannot do. This is bigger than the participants in this case.
Does Cole Township have do they use any forms that they provide to people who want to request a refund?
I don't know the answer to that.
I mean, because, you know, the way you have this set up now, they could have verified this letter, and you'd say, not enough. That doesn't put us on notice of what we need to know. And then they add another piece of information, and you say, not enough. It doesn't meet the statutory requirement. And I'm just challenged by the fact that had someone responded to their request for information regarding the actual costs, we probably wouldn't be here. I mean, this is a $100,000 overcharge. I mean, which obviously they perceived in the context of everything that was going on here with the purchase of this facility. So, I mean, it just seems as though your client is taking a position that can change with the wind in terms of what is, in fact, necessary to meet what, you're arguing to us is a statutory requirement.
Justice, with all due respect, I don't think we're taking a position that changes with the wind. I think what we're doing is we're following the statute as it's written. The statute as it's written creates a remedy and a right. And what the statute steps provide for is how that right accrues. That right doesn't accrue until several things happen. First, there is a payment under protest. Second, there is a written and verified claim that is submitted to the political subdivision. Third, there is a denial of refund. It's only then do you get to then, if those things happen and subject to the limitations set forth above, it's only then do you get to the step where you have a claim that you can pursue in a court of common pleas.
See, here's my problem with that, and I'm looking at the statute because I agree with your argument. This statute and the request by the taxpayer is premised on a knowledge that the fees were fees to which the subdivision was not legally entitled. How would they know that unless they know what the township was legally entitled to? And that was their request for information. I mean, at this juncture, I mean, how did they file anything that's verified unless they can make a determination that the township got money to which they were not legally entitled?
Justice, I'm going to go back to what I had said previously, and that is they filed a complaint. It was verified. They filed a complaint that was verified. It survived preliminary objections. So they were able to file a claim based upon that knowledge because they sought a refund. So to suggest that they couldn't do the same thing, you know what they could have done? They could have submitted a draft complaint with a letter that said, we're demanding a refund. If you don't supply us with the refund, we're going to file this complaint in court, and the complaint could have been verified. And that would have satisfied the act. You know what they also could have done? When this issue was raised, and it was raised within a 3-year period of time that's set forth in the statute, they could have withdrawn their action, discontinued it without prejudice. They could have then taken their complaint that they had filed, they could have sent it back to the township, and they could have cured this. But they didn't do that. They rely upon the F.P. Willow case, and that's what happened in the F.P. Willow case. They filed a lawsuit. They hadn't filed a claim letter. They went back and filed the claim letter they went back and tried to cure, and the court relied upon it and looked upon that. This happened in 2017. We're in 2024. Not once did they try to cure this. Not once knowing that the issues were out there. These issues were raised in 2018, within a year. The issues that they didn't follow the act. They were argued in preliminary objections. They were argued at 2 summary judgment motions. They had plenty of time to cure this. They didn't.
They won all of those preliminary objection motions, did they not?
Sure, they won them, but in winning, the court never said that the Refund Act doesn't apply.
But did you ever make the determination of whether they were correct and entitled to the refund? I mean, you seem to be asking this court to sanction all kinds of technical defenses when we've never even gotten to the substantive issues. You're saying a lot of things they could have done in the last 7 years, and the short answer that I keep running through my own head is, did your client ever perform an analysis to see whether or not they were correct and just cut them a check back for the overpayment?
My client actually has a counterclaim that was never decided. My client has a counterclaim based upon additional costs that were incurred.
My question. Did you ever perform an analysis to determine whether or not they were correct and they were entitled to the refund?
The analysis is part of the counterclaim. As part of the counterclaim, they're not entitled to the refund that they're asking for. That's our position. That counterclaim has never been adjudicated. It wasn't even referenced by the court in what they did below. And so, but it's not a technical defect. Striking a provision of a statute is not a technical defect. Failing to comply with something that the legislature says you must comply with is not a technical defect.
Counsel, isn't your answer to these questions that there's nothing in the Refund Act that requires you to respond to an informal discovery request or to do a calculation or anything like that? It's their responsibility to properly present a claim before they can go to court. The statute imposes no obligation on your client.
That's exactly correct. The statute imposes no obligations, and what Stranahan and Aronson previously indicated is that this act requires a strict compliance and a strict application. And to soften it, to give a liberal construction to say you don't have to comply with the verification is contrary to those decisions. I'd also point out is the decisions that the county rely upon, F.P. Willow and others, none of those decisions, even though they were reviewing a statute, none of those decisions employed a Statutory Construction Act analysis. None of them. I said that this case is bigger than the parties that are before you, and it is. And the reason it is because this is a slight tear in the fabric of the jurisprudence of statutory construction. What's the next step that happens? The next step that happens is no longer, if verification is no longer required, maybe written is no longer required.
Maybe notice isn't required under the Political Subdivision Tort Claims Act before filing a civil claim against the subdivision.
This could be applied across the board to any statute if allowed to stand. The lower courts must acknowledge, they must know that when they are reviewing a statute and they want to perhaps relax it, revise it, or try to carry out its intent and purpose, they've got to follow the Statutory Construction Act and those principles that this court has established over and over and over and over again.
Thank you, Mr. Winfield. I think we understand your argument. Let's hear from Mr. Garrigan.
Thank you.
Chief Justice, the court. May it please the court, my name is Frank Garrigan. I'm here on behalf of the County of Northumberland. As this court is aware, the County of Northumberland submitted a request for a refund. Now, I understand that Justice Robson has brought up the matter of whether or not this was in fact a request for a refund. But the issue, one of the issues here is that at the time, the part of the determination of whether or not the county is entitled to a refund is what was the township's fee, like how much did it actually cost them to administer the permit. We knew there was no way in the world it was over $200,000, but we had no way of ascertaining the amount that was due the refund. And in fact, in discovery, we later found out that the township's numbers that they were providing for what the actual cost of administering the permit was, because they had an outside contractor do the all the inspections, all the work related to the permitting, they were actually getting a kickback from the outside inspector. So we would not have known that but for the fact that we determined these things in discovery.
Counsel, but that happens all the time in refund actions. And what happens is you file the claim for the full amount. If you want to get to court, you file the claim for the full amount. If you can't figure out what's up, I mean, consumers do this all the time. Lawyers make a living out of it. You work for the county gets refund claims.
But certainly we
refund the amount you seek. If you don't know the smaller amount, you seek the full amount. And that gets you in the door of the Court of Common Pleas if it's not paid.
But certainly we knew that they had some expenses related to this, but we did not know the amount. And we said, please provide us with the amount, and if you don't, we are going to seek a refund by filing a complaint.
Which you were able to do. You were able to file a verified claim, and what did you seek as the refund amount in your verified complaint?
We sought the entire amount that was the percentage above, and whatever it, I believe we also included a proviso, whatever the amount was that was not actually charged by the outside, by the third-party contractor, which it turned out there was an amount.
You're saying you could not have done that in a verified request pursuant to the statute?
Well, what I'm saying is that we would not have any idea what the dollar figure was, but we did state, and frankly, I would, this is an interesting case in that it's a municipality versus another municipality, and I would dare say that there's probably the only refund case out there in which that has occurred. We submitted a letter on Northumberland County letterhead signed by the chief clerk, hand-delivered by a county commissioner to the township. There's no way that they didn't have notice. And the whole point of this verification process is to first give the township the opportunity to make a refund without having to go through the process of filing a complaint. In this case, there are two cases, KPI Malvern and FP Willow Ridge, with both, and a number of other cases which state that the 3-year, for example, the 3-year statute of limitations, or it's not a statute of limitations, it's a notice provision. And I would just point out that while my colleague says that there's Stranahan and Aronson both refer to strict construction of the Tax Refund Act, both of those cases are very specific, and they're the only ones that reference that this is to be strictly construed. Those cases involved attempts to file class action lawsuits outside of the Tax Refund Act, and it's my belief that both of those cases are saying you cannot go outside of the language of the Tax Refund Act, and the Tax Refund Act does not say that you are entitled to pursue class action. The FP Willow Ridge case, for example.
Rich, I think didn't you threaten a class action?
We did.
Yeah.
Well, we threatened, Your Honor, but then we just.
You threatened a class action, and you threatened to file suit if they didn't give you information. You didn't threaten to file suit if they didn't give you a refund.
I understand. However, you must. This court.
The reason why it's important to me is the section that gives you the right to file suit, because it says, in the event of a refusal or failure on the part of the authority of the political subdivision involved to make any such refund of taxes, licensing fees, penalties, fines, or other monies to which the political subdivision is not legally entitled, or refusal or failure to pay interest as required by Section 1. It's the failure or the refusal of the authorities to make such refund as required by Section 1.
And in this case, they never refused, they never did anything.
Right, but
we sent them.
You can count that as a failure if you asked for it. But it seems to me that the General Assembly is saying, like they say with the notice provision under the Political Subdivision Court Claims Act, for your cause of action to accrue, you first have to have notice and demand and a refusal or failure to pay.
And, Your Honor, Justice, apologies. The Tax Refund Act is supposed to be a way for the average citizen to go about getting back money to which they are entitled. And if you are to read it, now, in this case, we have the County of Northumberland, but if this was the average citizen who sent out a letter like this, the whole point of the notice provision is to give the township notice that there is a claim here. And to then, the burden shifts to them to go and find.
You didn't give them notice of a claim. You gave them notice of a question. You questioned whether it was excessive. You cited the case law that said it could be excessive, meaning you knew this was an issue of whether it was a fee versus a tax. But you never said in your letter, we believe this is excessive. We believe we are owed, we should get the whole thing back. It was basically an informal request for information.
Well, I would point out that this court did not, this court limited what the matters were for, that it was going to hear on appeal. That was not one of.
That's a great argument. That's a great response.
I'm just saying that I wasn't entirely prepared to come here and argue whether or not the initial letter was in fact a demand letter, because that was not a matter that was requested for on appeal. But that said, I think that the average citizen, if they sent out this letter and stated that they were going to file a lawsuit demanding the money back, that is a demand. You say you're filing a lawsuit, that is a request, that is a demand. And that would be what my argument would be.
Let me get you back on track so my colleagues
Okay.
aren't frustrated. The General Assembly said verified. What did they mean?
Okay. That's a little unclear because they don't really, there is nothing in the Tax Refund Act defining what the verification was. We acknowledge that the rules of statutory construction define verified, and that there was not a verification, there was not an acknowledgement. I will concede that that is the case. But that said, if this court is to, one of the rules of statutory construction is that you're not, the statute should not be construed so as to result in an absurd.
That's only if the statute is ambiguous.
And
the General Assembly is absolutely entitled to pass absurd statutes.
True. And in this case, the absurd result would be that since KPI and Willow Ridge both state that that you can go, as long as there was notice that was given, that you can go back after the 3 years, and the 3 years, first of all, and I would just point out that it says you shall submit a request within 3 years. And yet there are 2 cases out there wherein, for example, in FP Willow Ridge, they did not submit it within 3 years. They submitted it after 3 years. So clearly, in the past, this statute has not been strictly construed.
Well, the last sentence of this section refers to a written demand. Mm-hmm. It doesn't refer to a verified demand or
right.
a verified written demand.
Correct.
So are we talking about 2 different things within the context of this section?
That's a great question. I don't know why they left out the word verified in.
Well, you would make the point that you did make a written demand. And
I
understand Justice Robson's discussion. I sort of raised it myself early on, but I think the Commonwealth Court proceeded under the notion that this was actually a claim for a refund.
That certainly seemed to be the impression from all the lower courts, that this qualified as a written claim, and we did submit a written claim. We can see that it was not verified. Obviously, the complaint itself was verified, and in FB Willow Ridge, after the fact, after the 3 years expired, all that the notice was saying, hey, by the way, here's our written complaint, and our previous demand letter is attached to it. And they said, that's good enough. So the county is of the belief that the absurd result that would happen here is that as soon as this case ends, if you guys find against the county, we're going to be filing another claim. They certainly were on notice. There's no prejudice to them, and we're right back to starting this case from the get-go again. And what was the prejudice to the township? They knew full well exactly what was going on from the beginning of this thing. They were basically taking $100,000 to which they were absolutely statutorily not entitled.
Is there precedent for us to read prejudice into the statute as a factor in determining whether your client complied with the gate threshold procedural requirements to get access to the court?
There is, when the question in FP Willow Ridge, they stated that one of the factors to take into consideration is was there any prejudice to the municipality by the notice coming in after 3 years. So yes, that's one of the factors.
Counsel,
Yes.
let me just clarify. You don't have an answer to my question. How do we reconcile the reference to a written demand in the last sentence of Section 1 with the verified and written demand in the earlier portion of that same section?
And my answer, and I know that it's unsatisfactory, but my answer is I don't know why they didn't put verified, why they didn't repeat themselves. But clearly
Maybe they only meant to say written. If I were you, that's the answer I would.
Yeah, I would. Yes, we certainly, and I don't think there's, I understand Justice Robson disagrees, but my argument is.
I don't disagree yet until I put pen to paper.
I got a vibe. The county, or the county submitted a written demand for a refund, and I'm sorry, I lost my train of thought.
And you did it within 3 years.
Oh, sir, absolutely. We submitted the written demand within a month. This was not, again, there is no shock or surprise to the township. This was in every newspaper in Northumberland County. This was a big deal. And we had a commissioner hand deliver this letter to them. So was it verified? No, but we did have a commissioner deliver a letter written by the chief clerk of the county on county letterhead stating we would like a refund.
Okay, I think we get it, Mr. Garrigan. Thank you. Thank you both. Very well argued. I'm not sure the subject matter will inspire our high school students to become attorneys, but it was very well argued.
That's not true. I see they look interested.
Thank you.
Thank you. Mr. Minner, call the next case.
CKHS Inc. and the Foundation for Delaware County versus Hldgs representing CKHS Kelly, Gene Sargent Jr. representing Kelly, Mr. Robert Meyer.
In this discretionary appeal, the trial court issued a preliminary injunction barring the closure of Delaware County Memorial Hospital. Its decision was reversed by the Commonwealth Court, The question before us is whether the Commonwealth Court correctly applied the highly deferential standard for reviewing the grant of a preliminary injunction, namely, whether any apparently reasonable grounds exist to support the trial court's decision. Good morning.
Good morning, Chief Justice Todd and Associate Justices. Jim Sargent here, and with me is Andrew Stafford, my colleague from our office in Newtown Square.
Making a repeat appearance, I see.
He is. He's the stalwart in our firm.
I see. He's the brief writer.
More than that, he's the brains of the outfit.
All right.
Thank you very much, Your Honor. I'm sort of not only impressed by the weight of this occasion, but also by the weight of the material over my head. It makes me intimidated. I hope it doesn't fall down.
Well, I'm glad you were paying attention.
Your Honor, we are here from an appeal of a preliminary injunction, which is obviously a unique procedural form of relief. We would argue that we satisfied the 6 elements that are required for preliminary injunctive relief. The first being immediate irreparable harm. I can't imagine anything more immediate and irreparable than closing down a hospital that's been in a local community for generations. People have gone there to deliver babies, to attend to acute illnesses, for emergency room care in a disadvantaged community, lower economic community in Delaware County. I'm interested to note, Your Honor, that Violet Oakley was painting her murals here when Delaware County Hospital first opened its doors on January 1st, 1927.
Noted.
I'm sorry, July 1st, 1927. So immediate irreparable harm here is defined, of course, by what happened to this community hospital. It was closed. It arose, the claim arose from the breach of a clear contractual agreement to keep the hospital open. There is no other remedy. It can't be addressed in damages. There is absolutely impossible. The parties stipulated that if the contract was breached, that would result in irreparable harm. I want to return to that. That's a very important point, which the Commonwealth Court essentially discounted. The second element, there's greater harm from refusing to grant relief in this instance than from granting the relief. Clearly, we just sought to have the hospital continue. That's what Prospect had agreed to do. So it's a much greater harm to the community to close down the hospital than just to say, stay the course, Prospect. You can't close it down now. It was necessary, the relief, to preserve the status quo. Obviously, the status quo was the open hospital. That was changed by Prospect. Likelihood of prevailing on the merits, the fourth element. We think very strongly that the contract is clear. Prospect agreed to keep the hospital open, and there's no excuse for not keeping it open. Now, Prospect would like this court to interpret the section 11.15, which allows Prospect to discontinue specific services which are no longer commercially reasonable to maintain, as engulfing 11.16, which says they'll keep the hospital open. And so...
Can I just interrupt briefly on that?
Absolutely.
Isn't there a revocation by the Department of Health regarding the certification to operate as a community hospital in effect right now?
Well, that's not exactly correct, Justice McCaffrey. What happened here, and it's...
I wanted to kind of answer that question in conjunction with your position that there's a greater likelihood of success on the merits, because if the hospital is closed by order of the Department of Health, I wanted you to answer that question. It's almost like a moot issue to me, but...
Your Honor, Justice McCaffrey, that's a self-fulfilling prophecy. So what happened here was that in the spring of 2022, Prospect started terminating services. It terminated the acute care services. It previously had terminated labor and delivery. Then in September 21st, 2022, Prospect announced it was closing in the local press. It was closing the hospital, and it told the 200-plus employees, you no longer have a job.
So it was almost like a preemptive breach.
It certainly was. If you don't have personnel, you can't run an ER. And Prospect self-reported to the Department of Health saying, we don't have any personnel. Well, the reason they didn't have any personnel was they chose, as part of their plan, to turn this into a behavioral health center to shed all the employees. So the Department of Health, and this is what really the dissent held, this is what the trial court held, all you have to do is rehire those employees and the Department of Health certification goes away.
Thank you for that.
So
Counsel, if I might, can I
Yes.
ask you to focus on the evidence of irreparable harm that was provided during the injunction hearing? You know, as I understand the issue, this is a question of whether, under the standard announced in Summit Town Center, the evidence of irreparable harm in this case was sufficient to meet the specific data supporting irreparable harm requirement that was set forth in Summit Town. So what kind of evidence was there of irreparable harm?
Thank you, Justice Donahue. There was testimony from the director of the Department of Health in Delaware County, which strongly reinforced the concept that when you close down a hospital in a local community, the local community suffers. Now, I also point out again that the parties had stipulated to irreparable harm.
Let me just focus on the actual evidence first, because they stipulated to a lot regarding preliminary injunctive relief. But the evidence, the expert testimony that you just described, strikes me as being very similar to the expert testimony that was offered in Summit Town Center, which is, well, other tenants will leave because that large space is now vacant. It will be more difficult to release property within the Summertown Mall because of the, and this court said, not good enough. We're looking for data. And so I'll ask you again, because I don't think there is any such evidence in this case. For example, the number of emergency room visits that will be necessary to move to another hospital, or the inability of adjacent emergency rooms to handle the population that will be, sent as a result of this closure. Is there anything like that in this record to support the irreparable harm claim?
Justice Donahue, I will preface my answer by pointing out that the Prospect announced it was closing the hospital September 21st, 2022. The complaint was filed on September 28th, a week later. The preliminary injunction hearing was on October 7th, 2022, essentially 3 weeks after the closure announcement. And the practical reality is the impact on the community could not possibly be felt or measured within that time frame, which brings me to a very important point. Two, in fact. Summit Township involved a case where there was clearly an economic remedy. There were damages that could be calculated. There was actually a liquidated damages clause in the contract. And the testimony that a 1% shareholder was going to call, 1%, tenant was going to cause a tsunami of vacations in this 550,000 square foot shopping center just didn't ring true. And I think the court,
Let me ask you, the 3-week period, and you know, I understand the global view that any type of closure of a hospital like this is going to have an impact, but in the 3-week period between the closing of the emergency room and the preliminary injunction hearing, were there any patients who presented at the emergency room who had to be sent somewhere else?
there were anecdotal instances of that.
I'm not talking about anecdotal. I'm talking about, was there evidence in the record that in this period of time there were 10 patients who had to be transferred, or 7 or 6 or 20? I mean, was there any kind of evidence like that?
There was not, Your Honor, as far as I know. But let me remind Your Honor of what this court said in 1904 in Hicks versus American Natural Gas Company, a very endearing quotation. It is somewhat embarrassing to an appellate court to discuss the reasons for or against a preliminary decree, because generally in such an issue we are not in full possession of the case, either as to law or testimony. Hence our almost invariable rule is to simply affirm the decree, or if we reverse, to give it only a brief outline of reasons. And then in that case, the court said, only if it is plain no grounds exist to support the decree, or that the rule of law relied upon was palpably wrong or misapplied, will the court reverse. That has been the tradition of this court since 1904.
I understand that. That's why I'm continuing to focus on the standard that was set in Summertown Center. This is a mandatory injunction. I mean, this required rehiring staff. This required reopening a facility. I mean, this isn't a prohibitive injunction where I believe the standard is less onerous. You know, whether or not it appears obvious to anyone in retrospect that this was a spurious claim by the owner of Summertown Center, the court's decision is really based upon sort of a data-driven analysis of the evidence to support an injunction that's mandatory. And as I see it, I mean, that appears to be the, to me, the flaw in the case that you're presenting. I don't know if it's one that can be overcome, but it just seems to me that the opinion of an expert that says essentially most times, maybe all times, this has an impact on the community, which was the essence of the expert opinion in this case. I just don't know if that's enough to support a mandatory injunction.
Well, Your Honor, I would raise an issue as to whether it's mandatory or prohibitory, because, in fact, the injunction simply held Prospect to its bargain. It enjoined it from closing down the hospital.
They had to hire back staff.
Well, Your Honor, that is a self-fulfilling prophecy. They chose to fire all the employees. So if they have to hire all the employees back to live up to their promise to keep the hospital open, then they have to hire the employees back.
Well, that's what they wanted in Summertown Center also.
Well,
in Summertown Center, they wanted that tenant to move back in and operate the shoe store.
And there was evidence, Your Honor,
After they moved out.
there was evidence of how much it would cost, and it was an economic analysis in Summertown Center. We could not possibly perform an economic analysis of the harm to the residents of this community when that hospital was closed down. That's what differentiates this from Summertown Center. I will point out that in both Summertown Center and in this case, the intermediate appellate court made the mistake of substituting its judgment for that of the trial judge. And this court called out the Superior Court in Summertown Center for doing so. It's exactly what the Commonwealth Court did here. Recited the same testimony and decided for itself, as Your Honor is suggesting you might do, that this isn't sufficient. But that's not the standard that this court has adhered to for well over a century. The standard has been...
It is a standard if what we are doing is applying a legal test. did what the lower court do here meet the legal standard established in Summit Town Center? Now, your argument that this is different because certainly in no case could monetary damage award correct this harm, that might be the difference. I'm just testing the evidence itself based upon the legal standards set in Summit Town Center for an injunction such as this.
Well, perhaps, Justice Donahue, we should discuss what that legal standard is, because my understanding of the legal standard established and reinforced in Summit Town Center is that if there are apparently reasonable grounds, this is actually quoting Hicks from 1904, then the trial court will be affirmed, and only if no grounds exist or the legal basis was palpably erroneous or misapplied will the court reverse, will the appellate court reverse. That's the standard I understand. Now, Mr. Beyer, who has accused us of slogans and modifiers, likes the term concrete evidence. That is not an appropriate standard. There cannot be concrete evidence in an emergency preliminary injunction setting. Perhaps if at the end of a trial on a final injunction you could call out concrete evidence. I don't even know what concrete evidence is. What is that?
I think the problem, though, is Summit does use that language. I think, though, you raise an interesting point, which is how far does that language really go? Did it really alter anything in our jurisprudence? Was it used out of context? You got to kind of go look at the cases that Summit Town cited for that proposition to see whether they have applicability here. I think your better response, which I think Justice Donahue tried to feed to you, is there is no this loss, this harm, which I can't imagine people don't understand that closing a community hospital results in harm to a community, is irreparable. Is irreparable sort of per se, because there's no way to rectify the harm with monetary damages. There's no amount of money that can be paid to once that hospital is closed to compensate the community for the closure of those local healthcare facilities. And isn't that the answer? That it is in Summit. This is not if it was purely economic harm, it wouldn't be irreparable anyway. That's why the whole Summit Township thing doesn't really work in a case like this.
Thank you, Justice Robson. I couldn't agree more. I mean, this is not. Excuse me? No, I agree. It is.
But your problem is, and you haven't addressed it directly, is the Summit Town language. I can't blame the Commonwealth Court and Judge Mr. Beyer and his clients for hitching their wagon to that language.
And it is harsh, and I mean, it wasn't just hypothetical. I mean, for example, they said there was no evidence of vacancy rates before and after closing to support the retention of these stores. I mean, they backed up the notion of concrete evidence with the type of evidence they consider to be concrete.
Yes, Your Honor. But the fact is that in Summit Town Center, there was an hypothesis which was facially implausible, that the vacation of a 1% tenant was going to cause a massive vacation on the part of all tenants, and there was an economic remedy. It was clear that the issue was damages. And so in juxtaposition to this proposition that a 1% tenant leaving is going to cause everybody else, even the big stores, to leave, the court said, well, you've got to come up with something more than that. And that's why the term concrete was used. But as Justice Robson has pointed out, in this context where you have a judge, and quite frankly, trial judges for this court are the eyes and ears, the boots on the ground in these contexts. They are people who have grown up in these communities. Here you had a senior judge whose father was a doctor in Delaware County at Riddle Memorial Hospital. He's the sort of person you have to rely on. You can't be there. You can't make those decisions. And what he did was to take the obvious, which no one could deny, that in this community, a hospital that's been open for 100 years is going to develop a whole dependency among the population there. And combined with the testimony of this 22-year head director of public health in Delaware County, he comes to the conclusion that an emergency preliminary injunction is appropriate to stop the hemorrhaging of health care from this particular location.
Do we know from the record how many inpatients there were in the hospital prior to the announcement of the closure?
Well,
we know when the complaint was filed there were 9 inpatients. Do we know what that number was prior to the announcement of the closure?
Well, the announcement of the closure was September 21st, 2022. The ICU had been terminated months and months before that. So had labor and delivery. So all of that information about the impact on, shedding patients, all related back to steps that Prospect had taken to, slowly wind down the hospital's operations. So I don't know what those statistics would be. I don't think they'd be particularly useful in this context. Well, I would sum up by saying we demonstrated the 6 elements for emergency preliminary injunctive relief. This trial judge rendered a decision based on the facts and the appropriate inferences from the circumstances, and the Commonwealth Court substituted its judgment, did not defer, did not apply the highly deferential standard of review.
All right,
Thank you, Your Honor.
Absolutely.
I'm sorry, but what I think is really important about this case is that this contract was made by the parties, and it said that they both stipulated that if the hospital was closed, it would be irreparable harm. Why isn't that enough? Why are we so concerned with the Summit case if we have 2 parties who agree that there's irreparable harm?
Justice Mundy, again, I couldn't agree more. I was going to raise that issue earlier. The fact is that in all of the cases that have been cited in which the Commonwealth Court or my worthy colleagues have said we don't enforce those provisions, they all involved economic damages, almost exclusively. So in this case, it's not just boilerplate. Who better than Prospect and the selling hospital would know the importance of this hospital to the community? I think it's almost an admission against interest by Prospect. So I would enforce that in this context where there are no economic damages.
Can I take that one step further? As I understand the contract, it also said that the parties shall be entitled to a preliminary injunction. So why was there an attempt to enforce that provision? And is that enforceable?
Absolutely. If that's the only form of relief, that's, again, an admission. You can't remedy this breach in damages. So then it's a breach without a remedy. That can't be possible under the law.
You couldn't use that clause to come to the court and say to the court, we don't even have to present to you all the elements of a PI. We have a contract that says we're entitled to it. Here's a precipice to enter a preliminary injunction. You're not suggesting that.
Absolutely not.
So at most, what you're suggesting is they were contractually stopped from contesting your preliminary injunction.
Well, that's a good argument. I hadn't thought of it in quite those terms, Your Honor, but the practical reality is this is contextual. If it's a boilerplate provision in a contract where damages are the appropriate remedy, then the court can disregard it. If it is a a provision in a contract such as this, it's maybe an admission, maybe an estoppel.
Like a irreparable harm provision in a covenant not to compete.
Correct.
What is the rule you would suggest we adopt when we're faced with an agreement like this in a contract?
I think it's a case-by-case analysis. The court first has to satisfy itself that there is no monetary remedy. There's no remedy at law. If there's a remedy at law, then one has to scrutinize that provision to see if that's really appropriate. But in context such as this, where the two sophisticated parties acknowledge that a breach is going to cause irreparable damages and the only possible remedy is injunctive relief, then I think it should be enforced. I think it's compelling.
But every time there's a preliminary injunction request, the argument is there's no adequate remedy at law, correct?
It may
You have
be
to make that argument.
It may be argued, yes, Your Honor, but that doesn't preclude the court. The argument that this sort of provision could preclude a court from exercising its equitable powers is pure sophistry. Of course the court is going to scrutinize the context and make a decision for itself whether it's appropriate to apply the clause. It's appropriate here. It isn't appropriate in the context of a case where you can get damages. It's as simple as that.
Have we heard from everyone? Okay. Thank you so much, Mr.
You don't want me to summarize again?
I think we've got it this time. Thank you,
Thank you
Mr.
very
Sargent.
much.
Let's hear from Mr. Byer.
Thank you very much, Madam Chief Justice, and may it please the Court. I am Robert Byer, and I'm joined by my co-counsel, Ryan Monahan, and we represent Prospect Medical Holdings and Prospect Crozer, LLC.
Mr. Byer, could you bring the mic down just a little? Thank you.
Yes. We have summarized in our brief this Court's jurisprudence on the irreparable harm issue and on the standards of review, and for 50 years this Court has a consistent line of decisions in which the Court has required that the preliminary injunction elements, and in particular the element dealing with irreparable harm, be supported by evidence that is not speculative, that is not hypothetical, that is related to the facts of the situation that is being placed before the Court. The Commonwealth Court here correctly analyzed the expert testimony that the plaintiff introduced and found that it was lacking in the required specificity, that it was hypothetical, that it was conjectural, and that it was not based on actual data. Yes, this was a preliminary injunction hearing, but there was always the possibility and the availability of subpoenas that the plaintiff could have served to obtain evidence with respect to the admissions, with respect to the ability of other hospitals in the area to absorb the patients. And this is a context where we know that Mercy Fitzgerald Hospital, a full-service hospital, was located only 2 miles away from Delaware County Memorial Hospital, which at the time of these events was underutilized to the point where there were only 9 inpatients, and the hospital was losing staff.
Mr. Byers, listening to Justice Brobson's question and Justice Mundy's question, why are you not stopped from challenging the irreparable harm part when you stipulated it via a written contract?
Well, 2 points, Justice Doherty, in answer to that. First, estoppel was not raised by the plaintiff in this case, so that's not an issue that was ever asserted. The contract provision was asserted, but not in the context of estoppel. And we argued, and the Commonwealth Court accepted, that the majority position in the United States is that contractual clauses of this nature are not enforceable, that they are against public policy, because there is a public policy component that the court always has to apply in determining whether to issue a preliminary injunction.
Does that mean you entered this contract with not clean hands? If you know if it's in violation of public policy?
I can't answer as to why or how, the circumstances under which this contract was entered. That's not of record in this case, and I was not involved in that.
But the issue of that contract is before this court.
The issue is before you, and there's only one state that applies those clauses as written, and that's Delaware. The issue has not come up in Pennsylvania before this case, and every other court that has considered that has rejected it.
Mr. Beyer, though, I mean, this starts to unravel if this provision was a material part of the bargain. Because if you're saying now, if you're saying now that it's unenforceable, then the whole bargain is suspect. There was no meeting of the minds. If this was a material term to these people, to this foundation, that everybody, we all thought we agreed this was irreparable harm. We had no idea you were going to come in and argue it wasn't. Now, maybe a court chooses not to be bound by it, which I think is a different question. But I sort of disagree with you that they had to use the word magic, the magic words estoppel. I think what they're saying is, we had an agreement. They agreed with us that this was irreparable harm, and now they're arguing it's not. Why is that not enforceable? Maybe it's not enforceable to us, but maybe your client just has to be silent on this.
Well, that would be a position that only Delaware has accepted, and every other court that has considered it has rejected it.
I'm not sure I agree. I think every other court that has looked at it has said the courts are not bound by such a clause. But I'm not sure they've dealt with this specific issue, which is whether, in other words, we can look at this or the trial court can look at it from a preliminary injunction perspective and say, we don't see irreparable harm here, even though the parties have stipulated it to it. But I don't think those courts have said, oh, and by the way, the parties that have stipulated to it, one who stipulated can change their mind for the purposes of convincing us that there is no irreparable harm.
I don't know that there was that level of specificity in the cases so much as a determination that there had to be proof of irreparable harm in those cases, and that proof could not be supplied by the contract alone. To argue that, well, those cases involved, some of those cases involved economic issues that aren't involved or easily provable here is beside the point, because where you do have economic issues, of course, you don't have a preliminary injunction. Those are not, if it's compensable, then the harm is by definition not irreparable. So I think those cases do support what the Commonwealth Court did in this situation. Again, we're talking not on the merits ultimately in terms of whether there should have been a permanent injunction, and that's an issue that I'll talk about momentarily in terms of the unique procedural posture that we are in now. But on this issue of was there sufficient proof of irreparable harm, I think the Commonwealth Court clearly got it right, particularly in view of this court's case law.
I apologize for interrupting you, but again, if you're in a major urban or metropolitan area, and there's one grocery store in this community that provides food to everybody, and that grocery store closes, does that community not suffer some form of harm because it doesn't have as easy of access to groceries?
I think it's a question of degree, and the question is whether it's the type of extreme irreparable harm that would justify preliminary injunctive relief.
Where are you getting the word extreme from?
Normally, the cases refer to an urgent necessity in terms of a preliminary injunction.
That doesn't mean the harm has to be extreme.
That's correct, Your Honor.
It has to be, all that's required is harm,
legally,
regardless of what level, and it has to be irreparable.
yes, but it can't be a de minimis harm. And here we have hospitals in the vicinity. I think there was evidence of 4 other hospitals, one of which was only 2 miles away. Now, obviously, you would like to have, in a perfect world, a hospital every mile, just as you'd like to have a grocery store every mile, but that world doesn't exist. And there is absolutely no evidence that was presented on this record as to how the closure of, or not the closure, I should say the transition of this hospital, because the term closure was never used by the defendants in terms of what they were doing. They were transitioning to a special hospital, a 100-bed mental health facility that the community also needed. But here, in terms of evidence that there would be any degree of prejudice, maybe some inconvenience that people would suffer, but we don't know what the effect would be because there's simply no evidence of that.
Counsel, let me ask a question. It's what bothers me about this case and the posture of it. If there is not a preliminary injunction in this matter, the harm just continues and goes on. What is the remedy for this breach? What is the remedy? Your client decided it was going to do what it wanted to do without consultation with the foundation and the other steps required by the contract, and they just go their merry way. Where's the remedy for that?
Well, first, Your Honor, you're assuming that there was a breach. Now, that was very much an issue. The Commonwealth Court did not reach that question. The issue here is whether this transition of services within 5 years, after 5 years from the entry into the agreement, was something that the contract specifically permitted in Section 11.15, and that 11.15 had to be read in context. That 11.16 that the trial judge relied on had to be read in the context of 11.15, and those issues had not been reached. They have not been determined. I think there is a substantial case.
How could that be? Didn't they have to consider the likelihood of success on the merits?
That would be a factor that would necessarily be considered in granting a preliminary injunction, yes. And
Is that what the trial court did?
The trial court did. The Commonwealth Court did not reach that question.
Yeah, I know, but the trial court had to decide that there was a likelihood of success on the merits, i.e. the contract was breached, correct?
Yes, and we suggest, and that issue, by the way, is subject to de novo review on appeal, and we have argued in the Commonwealth Court that the trial judge was wrong in making that determination. The Commonwealth Court did not reach that question.
But if we reverse the Commonwealth Court, it would go back for their consideration of the remaining preliminary injunction.
Yes, if this court were to determine that the Commonwealth Court erred on its determination of irreparable harm, then the remedy would not be to reinstate the injunction, and I can talk about that in a minute. The remedy would be to remand for further consideration.
But you'd have to vacate the Commonwealth Court's order reversing the preliminary injunction.
There would be a reversal and a remand, yes, but it would not necessarily be reinstated, and that would be because there needs to be a determination of these other elements with respect to injunctive relief, and the circumstances have changed.
But that's a reason, yeah, that doesn't make any sense to me. They had a preliminary injunction at the trial court. It went to the Commonwealth Court. The Commonwealth Court reversed it for one reason, and one reason only. We reversed that Commonwealth Court determination. You're saying you still get the injunction?
No, there would not.
Is there a stay of the injunction?
Yes, the injunction was stayed pending appeal.
Oh, it was? By who?
Judge Seisler in the Commonwealth Court on December 7, 2022.
I wasn't aware of that.
That injunction has not been in effect for over a year and a half. Meanwhile, circumstances have changed. The Department of Health entered its order that Justice McCaffery spoke about shortly after the Commonwealth Court's preliminary injunction, because the entry of the preliminary injunction actually had the effect of accelerating the departure of staff from the hospital to the point where the Department of Health, and we were, yes, it was self-reported, we're required to report to the Department of Health, and the Department of Health ordered that the facility be closed because it didn't have the staff. And we had an impossibility defense that we were trying to hire staff after Judge Schenken made his order. It was impossible, and then Judge Seisler entered the stay. When that stay was entered, before the briefing, before the argument in the Commonwealth Court, the plaintiff could have challenged that in this court. There was no challenge to the stay pending appeal. The appeal in the Commonwealth Court from the preliminary injunction was expedited on our motion, and then after the Commonwealth Court entered its decision reversing again, there was no effort on the part of the plaintiff to seek any additional emergency relief. The plaintiff could have gone back into the trial court under the rules of appellate procedure and moved the case forward for a permanent injunction. If there had been evidence of irreparable injury, that patients were suffering, that people were having greater injury because they couldn't get to an emergency room that was closer than the one that was 2 miles from this hospital, first of all, I think that would have been reported, and secondly, I think that would have been the subject of a renewed request for preliminary injunction relief, which the rules of civil procedure permit. We saw none of that from the plaintiffs in this case.
Mr. Barr, the other 4 hospitals that you said were in the vicinity, how many of them have emergency rooms?
I believe that all of them do. I would have to look at that, but certainly Mercy Fitzgerald has a full-service emergency.
The one that was closest, the 2 mile away
Yes,
one.
that has a full-service emergency room.
Okay.
And so in terms of whether, I mean, we have a unique situation here with this case at this point. We have looked and we have not found any situation where this court ever has reinstated a preliminary injunction that an intermediate appellate court had reversed this long after the fact. The closest that we have come to finding any situation like that was in the Giant Eagle case in, I believe, 1994, when the Court of Common Pleas enjoined mass picketing. The strike was settled. The Superior Court reversed the injunction about the mass picketing, and then this court reinstated that order mainly because it found the decision wasn't moot because there was a counsel fee remedy involved. And so, but we've never seen a situation where a preliminary injunction was granted and then stayed, not in effect, for nearly 2 years, and then reinstated without an analysis of the situation on the ground. And that's why the rules of appellate procedure allow for prompt review, but that's why the rules also allow the case to continue in the trial court. So,
Counsel, where are we on the permanent injunction hearing in this case?
the case has been stayed in the trial court now, pending the possibility of a sale of the hospital, and we attached that order to our brief. Plaintiff stipulated to that stay, and so the case has not moved forward. But there was no effort up until the time of the entry into that stipulation to move the case forward on the permanent injunction. Mr. Sargent's brief argues that our filing the appeal prohibited the taking of discovery, prohibited the moving of the case to trial. That is not the case under Rule 311E of the Rules of Appellate Procedure. So this is a case that involves a unique procedural circumstance, and that is why, Justice Brobson, and I apologize for the long answer, it would be inappropriate for this court merely to reinstate the preliminary injunction, even if this court were to find that the Commonwealth Court would.
I apologize, because I wasn't aware of the stay of the injunction. But, you know, we took the case, at least as I understand it, because of a concern that of creeping preliminary injunction appellate jurisprudence where we aren't necessarily clear, or maybe some of our cases have been applied a certain way by our intermediate appellate courts, to really get rid of the deferential, highly deferential standard that we give to trial court judges, any apparently reasonable grounds. What I think is complicated language in Summit Town of concrete evidence of a harm that you're trying to prevent in a preliminary injunction context. That's why we took it. Can we address those? Is this a wrong vehicle to address those issues? Is that what you're arguing?
I think this is the wrong vehicle at this point to address those issues, but if the court is interested in those issues, I would agree that it does require clarification. And there are two things I would commend to the court for its consideration. There are two really interesting law review articles. These are not in our brief, but there was an article by Judge Henry Friendly, 31 Emory Law Journal, 747 from 1982, Indiscretion About Discretion, in which Judge Friendly goes at great length about the use of the term discretion in the context of analysis of preliminary injunctions and appellate review of those decisions, and why perhaps some of the language has been imprecise and has failed to distinguish between different levels of discretion, and why this has led to confusion and erroneous decisions, in his opinion. Another great article by Professor Maurice Rosenberg entitled Judicial Discretion of the Trial Court Viewed from Above was in the 1971 Syracuse Law Review. And again, Professor Rosenberg talks about the confusion that's come about as the result of what he referred to as automated verbiage and knee-jerk terminology in describing the use of discretion, when what we're really talking about is the application of legal standards, which this court has summarized in the Summiton case. And Judge Friendly's argument is you measure preliminary injunctions against those legal standards, and the question is whether the evidence supported the exercise of those standards in a given case. And when you mess that up with language about discretion and highly deferential, it confuses the inquiry of what courts really are doing. And I think you have to distinguish between how you're describing the standard and then what that standard really is. What are the courts doing in these situations? What is the reality of appellate review? What is the reality of trial court review? And the term discretion is just so imprecise. Judge Aldersert has written about this in his book, The Judicial Process. Professor Dworkin in Taking Rights Seriously, Hart and Sachs in The Legal Process. And discretion is probably not the right term. But again, while these are issues that I think it is right for this court to consider and clarify the law, I don't know that this case is the vehicle to do that.
Why is that? I mean, why isn't this a case to test the concrete evidence standard of Summiton?
The court could do that in the context of this record, but I'm referring to the ultimate relief that would be granted at the conclusion of the decision. Is this court rendering what might be an advisory decision?
Would you like to sum up, Mr. Byer?
I just have one other question before Mr. Byer sums up, please.
Sure.
Why wouldn't this be an appropriate case for us to resolve the issue of a term of irrebuttable harm in the context of the contract for use in preliminary objections, since you've said that our court has not reached that issue yet?
Irreparable harm?
Yes, I'm sorry.
I believe that that should be determined on the basis of a full record with respect to how this contract was negotiated. And I think that should do so at a preliminary injunction stage rather than at a permanent injunction stage would result in, at best, only a tentative construction of the agreement. And I think that in the absence of a full record, we don't know what considerations the parties were taking into account.
And while I appreciate your comments on the discretionary nature of this case, and it seems to me that you would have a stronger argument, at least in my view, if the trial court, who was the court hearing the facts and applying the facts to the law framework here, particularly where there's not an obvious monetary relief in this case for the parties, if they had ruled in your favor on the preliminary injunction. I have a different view where the appellate court is the one who denied the preliminary injunction.
Well, and then we get into the question is, did the Commonwealth Court exercise the appropriate level of review and apply this court's precedent in Summiton and other cases? And that certainly is presented by the record in this case.
Thank you.
Now, do you wish to sum up, or have you?
We think the Commonwealth, this court should affirm the decision of the Commonwealth Court.
All right. Thank you,
Thank
Mr.
you.
Byer and Mr. Sargent. Expertly argued on both sides. Your clients were well served. Thank you both. We're going to take a lunch break until 12:45. afternoon. Would you call the next case, Mr. Minner?
Commonwealth of Pennsylvania versus Mary Aplt, representing the Commonwealth, Ms. Jennifer Robinson, representing Mrs. Hunt, Mr. David Collins.
Under Section 3755 of Title 75 of the Pennsylvania Consolidated Statutes, when the driver of a vehicle involved in an accident requires medical treatment at a hospital and there is probable cause to believe that the driver was operating the vehicle under the influence of alcohol or a controlled substance, hospital personnel are required to take blood samples from the driver. In the instant case, after Aplt, the driver of a vehicle involved in an accident, was transported to the hospital, law enforcement instructed hospital personnel to draw Aplt's blood pursuant to Section 3755. Prior to his trial on DUI charges, Aplt sought to suppress the results of those blood tests on the grounds that they were the result of a blood draw for which law enforcement did not first obtain a warrant, and which was not justified by any exception to the warrant requirement. The trial court granted Aplt's motion to suppress and held that Section 3755 is unconstitutional because it permits a warrantless seizure of an individual's blood that does not fall within a recognized exception to the warrant requirement. Before us, the Commonwealth argues that the trial court erred in addressing the constitutionality of Section 3755 in the first instance and in declaring the statute unconstitutional.
May it please the Court, Jennifer Robinson from Cumberland County District Attorney's Office, opposing counsel. As Your Honor just indicated, the Commonwealth does believe that the trial court erred by addressing the constitutionality of 3755. I submit that this analysis in this case could have been done through the lens of exigent circumstances, which is a well-accepted exception to the warrant requirement. My position is that by reaching the constitutionality of this particular statute, the trial court ignored clear precedent from this court that constitutionality should be reached as a last resort, and only when the language of the statute is clearly, palpably, and plainly in violation of the constitutional right of the individual.
Counsel, did the Commonwealth raise exigent circumstances?
So the attorney that handled the suppression hearing, I don't think she actually used the word exigent circumstances. However, she did, on the record, have the troopers testify to the surrounding circumstances, and there were documents submitted to the trial court with the suppression records that outline the time frames. In this particular case, the crash occurred at 10:34 p.m., and the troopers testified that, it was essentially mayhem. There was debris everywhere. There was the victim, Mary Staggs, who unfortunately did not actually make it to the hospital. She died en route. There was many things that need to be taken care of on scene, and the troopers eventually were able to was able to get to the hospital with Mr. Hunt. However, when he arrived, the defendant at that point in time was no longer conscious. I would note that the blood draw completed pursuant to 3755 was done at 12:30 a.m., so we were very close to that 2-hour window.
Can you explain why they didn't attempt to get a warrant? Was it possible? The timing was out of sync? No MDJ available? I mean, what was the explanation for failing to get the warrant?
So I don't believe that anyone at the trial court level specifically asked that. I would submit that because it was very close to that 2-hour time limit, it was the middle of the night, and in Cumberland County, we require ADA approval before the magistrate approval, that if they had sought to get that warrant, they were already at the 2-hour time, and then when you add on top of that the ADA approval and the magistrate, you're well beyond your 2-hour time frame.
Is that in the record?
They did not ask anything about the attempt or lack of attempt to get a search warrant. It was very much conceded that this was done at the request of the hospital pursuant to 3755. Yes.
Let's go back to the constitutional issue.
Correct.
When you look at 3755A and how it reads is anyone who determines probable cause shall cause a blood withdrawal by a medical firm. How is that not facially unconstitutional as a new exception to the warrant requirement, which is not so.
Your Honor, I would direct this court to history from the Commonwealth Court, who has...
With all due respect, we'll look at the history if it's ambiguous. It's not ambiguous. It says what's ambiguous may be who can determine, can my third grade student determine probable cause? Can the maintenance person in the hospital determine there's probable cause? The question I have is, you said they incorrectly approached the constitutionality of the statute. Very specifically, when you look at the plain text, it indicates the general rule is anyone, undefined person who determines probable cause, mandates a medical examiner to puncture someone's body to withdraw their blood. Tell me how that's not facially unconstitutional.
I submit that because the courts have interpreted that to mean the police are to make the probable cause determination, that it's really a mechanism for the police to execute their exigent search. The police would be determining probable cause and have exigencies and then request that the hospital submit the blood pursuant to this. And if you look at subsection B and the history of analysis from other courts in this particular section, they look at the fact that this section was actually enacted to prohibit lawsuits or protect the emergency personnel who are actually completing the blood draw.
You just added language to the statute that doesn't exist by saying police officers will determine the probable cause. That's not in the statute.
I do, yes, I agree. It's not in the plain language, yes. My position is that because...
You don't see a problem with that?
I believe that because the courts have reviewed it and taken the position that the legislature intended that to be a probable cause determination by the police, that that's a reasonable reading of the statute and would not lead it to be specifically any person making the determination. In the Commonwealth Court in Emory in 1985 actually specifically declined to find this statute unconstitutional, and they were analyzing the fact that the police officer would make that probable cause determination.
So in this case, and I'm just a little confused about the facts, why didn't the police officer try to get a warrant for the blood that was already taken? Am I misunderstanding the order of events here?
So my understanding from speaking with the trial counsel is that that essentially took place at the same time as this blood draw. The record is very lacking as to any detail other than that line of testimony from the trooper indicating that they had drawn medical blood. It's obviously not evidence in the record, but I can tell you that our office has historically had problems with that particular hospital and how they do testing, and it's not usually done in a way that's admissible in court. So I'm presuming that the trooper was familiar with that and knew that Holy Spirit Hospital only does screening for drug and alcohol using urine, and that possibly that blood draw was truly just really to medical purposes and had nothing to do with what they were looking for. But again, I can see the record's very lacking on that issue.
Okay, thank you.
I think,
Counsel, can I
yes.
follow up on Justice Dockery's point? So there are a lot of circumstances I think the statute could be applied in a potentially unconstitutional way. We're not here presented with a situation where a custodian at the hospital made a probable cause determination and tried to compel a physician to take the blood draw. Presumably, if the statute is written in such a way that only medical professionals can take the blood draw, that the medical professionals would at least have a basis for probable cause, whether somebody convinced them of probable cause or law enforcement did that. But there's a lot of facts that I can imagine that could tee up what here is sort of a facial constitutional challenge. Should we first determine whether this particular person's constitutional rights were violated before we allow them to facially challenge the constitutionality of a statute? Wouldn't the facial unconstitutionality of the statute be addressed better and more appropriately by somebody whose constitutional rights were violated? That's my question.
I would agree that probably is a better way to look at it.
It's like a standing question, which
correct,
which you did sort of raise, and it kind of goes to Justice Donahue's question is, and the procedure was kind of weird, right? Because this was a suppression motion.
Yes.
This wasn't a Commonwealth Court original jurisdiction action challenging the facial constitutionality of the statute. There's different burdens of proof associated with the suppression and things like that. But it does create a problem because there could be exigency here, but the decision by the district attorney not to push it at the hearing forces, almost cabins us to ignore it and treat it as if this person's rights were violated, when it's entirely possible. We could strike the statute as unconstitutional, but that doesn't necessarily mean the evidence is suppressed, right?
I would agree with that. I think that this particular statute has had different views by the courts over periods of time. If you look back to the 1980s and 1990s, this statute is referred to as a counterpart of implied consent, and it's referenced to be related to implied consent, but the courts specifically say that it's not actually implied consent. However, that's evolved over time, and it's kind of now become considered part of implied consent. So I think that if we really look back to how this statute originated, that changes the analysis. And I think it's also important to look at, after Birchfield, the General Assembly went back and they did amend 1547. This statute was not amended, which takes me back to the original intent of this statute really just being a mechanism for the police to work with the hospital under those exigent circumstances.
Only gets you so far, as Justice Doherty pointed out. The intent is what's written in the words of the General Assembly.
Right.
And unless if it's ambiguous, then you can try to figure out what the nature and the occasion of was for the statute and things like that to construe it. Are you claiming the statute is ambiguous?
No. No. I do think, though, to your point about constitutional rights violations, things of that nature, the trial court here completely ignored federal case law related to the Fourth Amendment, specifically Mitchell versus Wisconsin and other similar circumstances where the federal courts have said that contexts like this, where there is an emergency circumstance, there is a crash. In this particular case, there was a person who was deceased as a result of that crash.
Did you guys argue that? Did the DA's office argue it? Did you argue Mitchell? Did you say, Your Honor, you do not need to address the constitutionality of the statute because this defendant's constitutional rights were not violated?
From my reading of what was submitted by defense counsel and the trial attorney that handled the suppression, no one specifically said that. It was raised.
Did anybody generally say it? Or
in the
specifically say it? I mean,
In a way.
In a way. In defense's suppression motion, they asserted that there was no exception whatsoever that applied, and
in your response, you said there was, right?
The prosecutor put on evidence that I submit would support exigency, and it's not unheard of that a court could on their own recognize that. But I concede she did not specifically use the words exigency.
You're saying that Judge Maslin erred when he wrote in his opinion that I don't see an alternative basis on which to rule on this question. I must address the constitutional question, which is essentially what he wrote.
I would disagree.
That was error.
I would disagree with that. However, my bigger disagreement is the reliance on Myers. I think Myers is very much distinguishable from this case. If you look at Myers, in that particular instance, the defendant was not involved in a car crash. The defendant was taken and essentially became unruly and was medicated by the hospital, and the whole analysis was done under the implied consent statute, and he then essentially said that's the same as 3755 and relied on Myers, disregarding any other case law related to this particular issue. When we have other cases, such as Trahey, that look to potential exigent circumstances under these types of facts, even Jones-Williams.
Probe that a little, because to me, to get over very strong case law, somebody's got to say we couldn't get a warrant because in my view, the default is get a warrant.
Right. What's the exigent? You keep
Yeah,
going
I
around
mean,
the
what is the
constitutionality.
exigency?
What's the exigency?
Yeah.
So our position is the exigency is that the defendant at 10:34 p.m. was in a very severe crash that resulted in both him and the passenger being ejected. There was extensive response by first responders. The troopers were out on scene up until the time that the CARS unit, which is their crash reconstruction people, could come out at 11:18 p.m. The trooper that responded to the hospital arrived there at 11:50 and attempted to interview the defendant and request a consensual blood draw, but at that point in time, the defendant had become unconscious or was not responding to the trooper. the trooper was asking for that consent because at the time they were investigating the crash scene, they saw liquor bottles, they had witnesses saying the defendant smelled of alcohol, he admitted he had been drinking, fentanyl patches, cocaine, marijuana, all these things.
Why couldn't they call in for a warrant right then and there?
Again, so if you look at the timeline, we're now up to 11:50. The trooper and the defendant are at the hospital as
No,
we
I'm taking-
recognize alcohol dissipates.
Yeah, but Missouri versus McNeely basically said that the natural metabolism of alcohol is not a per se exception under the Fourth Amendment.
I agree. It not on its own, it is not. I think that when
What's
you
your exigency argument in this case?
I think when you look at the totality of the circumstances of everything that was occurring and the limited time frame they had to get that warrant, they were already at the 2-hour mark when he was at the hospital.
What's the 2-hour mark? Can you-
Under the DUI laws, the Commonwealth is required to get the blood alcohol draw done within 2 hours. There is a potential to argue that why you did not do it, but again, we're back to the problem of alcohol dissipating, so then your evidence...
What's the citation to that 2-hour law?
It's under 3802. It's one of the subsections under the DUI law.
Okay. So you're at an hour and 20 minutes?
By my calculation, between the time of the crash and the time the blood draw form was done at the hospital, they would have had approximately 16 minutes to comply with that 2-hour rule.
That's because they waited that long to do anything. I mean, so far, you still haven't mentioned anything about why they couldn't get a warrant.
Well, the troopers
Except
were...
they waited too long.
The 2 troopers that were responding were on scene with the victim who was severely injured and ultimately died. They were on scene with this defendant. They were basically managing a very large crash scene.
They weren't thinking about investigating at that point. They were thinking about dealing with the immediate issues of the accident.
Yes, essentially triaging. They had to close down the road. They had to call for the crash reconstruction team. They had to wait for fire and EMS to arrive. The victim was life-flighted out of the crash scene. So there was a lot of pieces, all which go to things that the courts have recognized can be exigent circumstances.
But can I just follow up? If you don't get the blood within 2 hours, it doesn't mean there's a per se rule that the blood's out. All it means is you've got to offer an excuse as to why you couldn't get it within 2 hours, or offer a relation back testimony, right?
Correct.
So, again, why didn't you just get it to 2.5 or 3 hours and provide the same explanation that you just provided to us, to the trial court, and then provide relation back testimony? You'd still have the blood, and the blood would still be good.
Potentially, yes, it would be. I think hindsight is probably 20/20 for the troopers. I think probably in the moment they are trained to get that blood within 2 hours, and that's the best evidence. We're required to put blood draw evidence in at trial. Again, with alcohol dissipating, which this court and federal courts have recognized, that's a problem for criminal prosecutions with the dissipation and the levels required to prove the DUI. In this particular case, a homicide by vehicle while DUI, it was very important to have accurate results.
So what did McNeely mean when it said the mere dissipation of alcohol is not in and of itself an excuse?
What does that
mean?
I read that as being if you have your standard DUI case and for some reason there's some problem getting that person to get their blood drawn and that alone is not going to be an exigency. But where you have not just the standard case, where you have something extra, you have a crash, you have the person unconscious, which I believe some courts have said that the person being unconscious alone constitutes an exigency, where you have fatal crash investigation, you have all of these different pieces working together. In addition to that dissipation of alcohol, I think that's where you get to the point where it's an exigency. I'm not asking for a per se rule that dissipation would somehow be exigency. I'm not saying in every single crash that would be the case, but I am saying that in this particular instance, due to all of those factors, that it should have been considered to be an exigent circumstance. And when you
review that, how do we review that? Do we review something like that on an abuse of discretion by the trial court? Do we review it as a question of whether the evidence supports the factual finding of exigency? None of which we can do here because the trial court didn't address it at all. But I'm just kind of wondering, is that, when you say it's a case by case, what is the role of an appellate court if the trial court says this particular DUI, suspected DUI, as opposed to a DUI checkpoint, this particular DUI has DUI plus.
So I think you look to the rule that says any totality of the circumstances for exigency, and you still follow that same analysis. It still has the trial court.
By the appellate court, is it?
I believe it is.
Counsel, all of that might be true, but somebody at the suppression hearing had to say, Your Honor, there are exigent circumstances here that permitted this blood draw. No one said that here. And that's the corner we're sort of backed into. And it's not a corner. I mean, it's what the trial court said. I've been offered no other choice here but to decide the constitutionality of this statute. And, I mean, unless somebody raises the issue head on, the trial court doesn't have to search for it.
I would submit that under all the circumstances presented to the trial court in the record, that it would not have been unreasonable to recognize it as...
Without somebody asking him to.
I understand the prosecutor did not use those words, but I would still go back to the defense attorney raising the issue initially, claiming no exception applied, and specifically listing out voluntary consent or exclusion.
On the suppression hearing, and again, I said the procedural posture is
right.
Unfortunate, because the burden was really on you at the suppression hearing to, you know, he was heading off. He was trying to head off. You're arguing there was an exception, and he teed it up and said, no exception. Just completely announced it to you. It would make sense that when your response should be, they're wrong. There is an exigency here, and again, I think that the corpse is dead here. But
we are in sort of a peculiar position with the procedural issues. The issue was raised as essentially challenging the constitutionality of 3755, which places some burden of persuasion on defense. I would submit there wasn't really a whole lot done on that side of things, but again, the Commonwealth bears the burden at suppression.
On constitutionality, and again, you're right, because on that issue, they raised it in the context of a suppression hearing where the burden's on you, but the burden of proving unconstitutionality on its face, which is higher than an as-applied challenge, is on them.
Right.
Commonwealth.
Yes.
If I'm not mistaken, when I read the notes of testimony from the suppression hearing, the blood had already been drawn for medical purposes prior to the request of law enforcement, correct?
So I looked into that a little bit further. The trooper testified and stated that there is nothing in any of the criminal complaint, incident report, any other reference anywhere whatsoever to that happening.
But we can only go on the record that we have, and on page 9 through 11 of September 12th, 22 suppression, although hospital personnel had already drawn blood from Aplt for medical purposes, 2 additional vials were drawn at the request of Trooper German. So the question I have is, in lieu of Commonwealth versus Shaw, the law enforcement knew blood had been drawn 2 vials. There is no exigency because the blood is preserved, yet no warrant was obtained or requested.
They did actually do a search warrant.
After, correct?
They did.
After the hospital, they drew blood again.
Yes. Yes, they did do a search warrant. I will note the language in the search warrant doesn't specify which blood sample they were requesting. They did a search warrant to secure the blood sample, and then they did a second search warrant to have it tested at the forensic lab.
Why do you say that? I mean, my understanding is the hospital was willing to hand them the vials.
That's my understanding as well, yes.
Well, then you knew which blood was going to be tested because the officer said, no, you hang on to it, we're going to get a warrant.
What I meant was when you look at the actual affidavit attached to the search warrant, the trooper doesn't articulate, I'm requesting the blood that was drawn pursuant to this request form. It simply says the hospital drew blood, that's the blood I'm requesting. So to me, that was a little ambiguous. It
also assumes that the blood that was taken for medical purposes still exists.
Exactly, and it assumes that the blood taken for medical purposes was in fact enough to test forensically, and that all of those other things that go along with that, which again, we unfortunately don't know.
Are there any other questions? No. We'll figure it out. Thank you. Let's hear from your opposing counsel.
May it please the Court, David Rudofsky for the appellee. I want to go right to the point that Justice Doherty and Justice Brobson raised. Rule 582H of the Rules of Criminal Procedure put the burden on the Commonwealth to show the legality of what the police did at any suppression hearing. As you've all noted, the Commonwealth made no attempt whatsoever to show that there were any exigent circumstances. As the AG concedes, this statute is void on its face to the extent it relies on implied consent.
So what obligation do you have asserting the facial unconstitutionality of a statute to establish that your constitutional rights were violated?
Right, and I understand that. And the argument that was made in the trial court and that we made in our brief to this court is that given the combination of McNeely, Birchfield, and Skinner versus railway labor, which was another blood testing case in the federal courts, those three Supreme Court cases made it clear, and it was McNeely that started it, that in this kind of situation, you need a search warrant. There can be no implied consent statute. So on its face, by authorizing a search simply on the request of a state trooper who says, I have probable cause, there's no argument that he didn't have time to do it. There's no argument that he had consent. Those are the only two possible exceptions to the search warrant requirement. What if you had a statute that said, because you live in a house that's taxed, you give up your Fourth Amendment rights, right? You implied a consent to a search of the house.
That's a little different than this because it specifically says you give up your Fourth Amendment rights. This was silent as to whether you needed anything more than probable cause.
But on its face, it allows what the Supreme Court has said is impermissible, and I think this court has said it as well, a search without a search warrant, without some exception.
But here again, I mean,
and that was the argument that we put it on the table at the motion to suppress.
The trial court here, and this will be because again, the posture of this is difficult. Did the trial court here actually rule that your client's constitutional rights were violated?
I think the trial court did rule that implicitly, if not explicitly. Said what the trial court did, and very clearly in the facts, they laid out the fact that after the accident, the client was taken to the hospital, the trooper German came, filled out the actual form, it's Exhibit 1 to the suppression hearing, filled out a form requesting the blood draw, right? Gives no reason why they couldn't have gotten a search warrant, they couldn't have called for a search warrant from the scene, or whatever on that level. Following that, after that blood draw of the two vials, they then get a search warrant, not for the blood draw, but just to seize the evidence and to test it. That's the fruit of the poisonous tree. That blood draw itself, on its face, was authorized by this statute, and the statute that authorizes a search of this kind, with the invasion into the body, which is Birchfield. Remember, if it was only a breath test, you wouldn't need a search warrant, but because of the invasiveness, you need a search warrant. It's the Commonwealth's burden to show that there's some exception. They didn't mention exigent circumstances. They made no argument about exigent circumstances. That issue was waived. This court on many occasions has said, both for the Commonwealth and for the defense, if you don't raise the argument below, you can't make it here. They now try to get around the clear unconstitutionality of the statute by saying, well, maybe it could have been exigent circumstances. They presented no evidence of that. Sure, they gave the background as to what happened, but they didn't make the argument that was exigent circumstances.
Let's assume they made the argument. Let's assume they said there were exigent circumstances. And let's assume there are exigent circumstances. Is the statute facially unconstitutional if it was applied in a constitutional way here?
The statute, in our view, is still facially unconstitutional. They may have a reason to say in this case, right, because there was exigent circumstances, or what if there was consent, right? What if the, he was alive and consented, The fact is they went under the statute. They didn't go under.
The statute does multiple things, right? The statute compels medical providers who are otherwise only authorized to provide medically necessary treatment. It authorizes, if not compels, you'd say compels them to take blood for a non-medically necessary purpose and shields them from liability for doing so.
Correct.
My question is, if the statute is followed and the police officer presents probable cause and the person draws the blood, but the police officer also establishes exigent circumstances, is the statute still unconstitutional? Because it operated the way it was supposed to. The doctors did a not medically necessary blood test and get civil immunity.
In that case, the reason is that if there are exigent circumstances or consent, and there's no record of this at all in this case, none whatsoever.
I'm trying to differentiate between this and whether it should be facial.
Right, and there may be a case out there where they can show it. That gives them an alternative ground to argue it. The statute itself, by authorizing this type of invasion, violates both the Fourth Amendment and beyond that, Article 1, Section 8. I mean, I think the other side misreads or overreads Mitchell versus Wisconsin. I mean, this court on many situations have said we're talking about a personal invasion of liberty. What the Supreme Court has said, and the best example I can give you is the dog sniff cases, right? Where the U.S. Supreme Court has said a dog sniff is not a search because it can only alert for drugs. This court rejected that in Commonwealth versus Martin 30 years ago and said a dog sniff of a person is not only a search in Pennsylvania, but you need full probable cause. And you've got Alexander with cars. I mean, you've differed from the U.S. Supreme Court on many occasions on this question of privacy. And so you've got a statute here that authorizes what this court and the U.S. Supreme Court has said you cannot do.
Well, what's curious here to me, though, is Section 3755 wasn't even necessary in this case. They didn't need this statute if the police officer just had gotten a warrant and asked for the blood. We wouldn't even be here.
And they give no, I agree with that, and they give no reason why the officer didn't seek a warrant. The thing about two officers on the scene, they could have called in and said, somebody get a warrant, we've got enough here.
Are medical providers required to comply with police officers set a warrant to the blood? Is it addressed to a particular medical provider? Is it a court order directing the medical provider to take the blood?
Right. I'm sorry, I missed that.
Is a warrant to secure a blood sample an order compelling any medical provider to take it?
I think it is. I mean,
it's directed to a particular
That's right.
medical
If this
provider.
officer had gone to a judge, gotten a search warrant, right, based on these facts, presented to the hospital, that's state action, right? Under this statute, the hospital is then compelled to do the blood draw.
Under the statute?
Without 3755.
Either way.
Well, I'm teasing that from the chief because I'm not sure there is anything that compels, in the absence of the statute, a physician or phlebotomist or whoever is authorized by medical licensing in Pennsylvania to take blood for a non-medical purpose. And I'm not sure, I mean, what stops the doctor from saying, look, I'm not taking this blood, it's not for medical purposes, bring your own phlebotomist in to come and take the blood, but I'm not doing it.
They may take the position. I think once a judge issues a warrant, let's say a judge issues a warrant to the hospital for a search of certain records, right, based on some probable cause, that the hospital has information relating to criminal activity of somebody else. Officer comes to the hospital and says, we want to do it. They say, I'm the doctor here. I'm not letting you in. They can go in and grab it. I mean, the same way if you don't let somebody in your house. It doesn't matter that it's the hospital or some other institution. Once a judge issues the search warrant, then the officers have the power to execute.
And the doctor may say, go ahead, take the blood. But I'm not doing it. Go ahead, here's the patient, draw the blood to the trooper.
You know, I don't think they would have refused in that kind of situation, but, you know, you'd have to deal with it at that point. The problem is, in this case, there is an established process in this hospital. They've got a form that they use, that they must have agreed to, which this officer filled out. Again, it's Exhibit 1 in the suppression hearing. It's a form that he requested. and the hospital gives the blood. I don't know of any hospital in Pennsylvania that wouldn't.
And they proceeded under the statute that's at issue here.
Absolutely.
Correct?
It's completely under the statute, and when they had the opportunity in the trial court to make any of these arguments, none, and they've got the burden under 582. That's why they've got that burden. I understand your point about the facial unconstitutionality. We put that on the table and said this statute authorizes law enforcement to proceed in a way that's completely contrary to the Fourth Amendment under McNeely and Birchfield. And of course, you know, the Jones-Williams case you had before where the court was split on that, that was because the evidence was clear in that case that the blood had been drawn by the hospital, and that was the blood that was tested. And therefore the court, it was 3-3 anyway on a lot of these issues. But that's the distinct difference, and this trial judge got it right. He said, this case is clear that the blood that was drawn, the 2 vials, gotten by the search warrant after the blood draw, the warrantless blood draw, that's the direct route here, and that those second warrants are the, as I say, the fruit of the poisonous tree of this matter. So I think on the table for this court, and you listed in your dispositional order on oral argument, did the judge properly reach the question of facial unconstitutionality, and is it facially unconstitutional? We submit that the court got it specifically right, and beyond that, the prosecution, the Commonwealth, failed to show any other grounds, consent, exigent circumstances, impossibility, whatever you want to call it, for this warrantless action.
Well, they might have had them, they didn't show them. While they might have had other grounds, they did not demonstrate them.
Hypothetically, maybe they did, but you know, I've never seen a case where this court said, well, hypothetically you had it, didn't present any evidence, and therefore
We don't usually say that. No.
we'll go ahead and do it.
All right. Any other questions?
I mean, a very strict rule on both sides. I've read your cases on waiver, believe me, and I teach this stuff. I said, raise it again, because the court's not going to hear it. You know. I'll say no more.
All right, thank you both very much. Call the next case, Mr. Minner.
Johnny and Jennifer Pignetti versus PennDOT, representing the Aplts, Mr. David Steger, representing PennDOT, Mr. David Steger.
May?
In this discretionary appeal, the Pennsylvania Department of Transportation filed a declaration of taking for 2 non-contiguous parcels in Philadelphia. The property owners filed a petition for the appointment of a board of viewers to determine just compensation and requested that the board value the parcels as if they were a single tract under Section 705 of the eminent domain code. The trial court granted the request, finding that the property owners satisfied Section 705 because the parcels had substantially identical ownership and were used for the unified purpose of storing vehicles, equipment, and materials for the property owner's business located elsewhere. The Commonwealth Court reversed, holding that the property owners failed to satisfy Section 705 because they did not demonstrate that the parcels were so inseparably connected in use that the injury or destruction of one parcel necessarily and permanently injured the other. We granted aliquotter to address whether, in so holding, the Commonwealth Court added a requirement to Section 705, which does not exist in the text of the statute.
If I may?
Please.
May it please the Court, Chief Justice Todd and Justices, I represent the Pignettis, the appellants, condomnees, and former property owners in this matter. The issue in this appeal specifically is whether 2 parcels condemned by PennDOT should be valued together pursuant to Section 705 of the eminent domain code. The Pignettis were the record owners of the 2 parcels. As such, since the property was taken, they're entitled to just compensation. The property was located in the Fishtown section of Philadelphia, and although it was not technically contiguous, at one point it is only separated by 5 to 10 feet. As Chief Justice Todd said, it was used for storage for the Pignettis' electrical business of trucks and equipment and other things. And as both the trial court and the Commonwealth Court both found, the condominies used the parcels for the same use and purpose. Both courts said that. Now, courts have recognized that properties may be worth together more than they are separately. In fact, PennDOT's own manual references this, that it gives to appraisers. It's referred sometimes as plottage or assemblage. And the purpose of 705 and the design of 705 is to ensure that just compensation considers that fact in appropriate cases. This is one of those cases. Section 705's language is clear and unambiguous and is met here. There are two, and only two, requirements of 705 for non-contiguous properties. 705 says that non-contiguous parcels shall be valued together if, one, they have substantially identical ownership, and two, they're used together for a unified purpose. As the trial court found, both elements are satisfied here. And unfortunately, the Commonwealth Court added a new requirement, which I'll get to in a second, regarding the use issue, and I will therefore start with that issue. As now stated for the third time, there was no question that they were used together for the same purpose. They were used for the electrical business.
It's not the same purpose, it's a unified purpose. And I think 705, if you look at the 1964 amendments to 705, it specifically references the case of Morris versus Commonwealth.
Right.
That was where the unified purpose comes in. Not the same or substantially similar uses, it's got to be a unified purpose. That was the holding of Morris, right?
Yeah.
So how are two properties that are used for storage of vehicles unified for purposes of valuation?
Let me address Morris, because I don't believe that's necessarily an accurate, even though that's what the Commonwealth Court said, I don't believe it properly applied Morris. So I'm going to get into the weeds a little bit, if that's okay. Okay, well, here we go. Morris is a very short case. It's a pre-code case. It was established it was issued by this court in 1951 before the code, and therefore it did not consider 705. As the court said, it was referenced in the comment section. I respectfully submit that the only reason it references is to reference the concept and not the actual words as applied by the Commonwealth Court below. So here's what Morris said, and here's what it didn't say. First of all, the Commonwealth Court, as I said, it's a very short case. There's only 3 paragraphs that matter. The first paragraph is the one that the Commonwealth Court cited to, which cites the Kostler case. That is what specifically the Commonwealth Court addressed. It said, see, this is what the test is, and it's quoting Kostler. That was not the holding of Morris. If you read the opinion, it says that the appellant raised Kostler, and it wasn't applicable there. It specifically said that Kostler wasn't applicable, and therefore that is not the law of Morris. So that's number one. Number two, if you continue to follow it down, it says, references a Montana case, in which that Montana case, which it said was basically what courts around the country are saying. And it says if they're used together as a single enterprise and the whole is depreciated in value as a result of the taking, damages suffered thereby may be compensated. Where lands are separately connected in use, the injury to one must necessarily and permanently injure the other. What that means is that if you've got properties that are used together in the same use, if you take one away, the injury to one must necessarily and permanently injure the other. That is the effect of taking it, and you don't. So what you focus on is the use and not the impact. It was the impact that the Commonwealth Court focused on. But most importantly is the next paragraph. That is where the Morris Court issued its holding. And the Morris Court said, unambiguously again, the important element is the entirety of use of the separate tracts. In that case, all 3 tracts were used as a unit. Where that is so, the injury to one tract is reflected as a consequent in injury to the entire enterprise. Again, no analysis of impact, it's the use. Here, it's clear that the parcels were used together as a unit. As Mr. Pignetti specifically testified, they were used for his business, they were needed for his, he specifically said they were needed for his business, and that he needed both of them. So, why were they needed?
If I take away his storage on one, can he store his property somewhere else?
Not necessarily, first of all, and second of all, that's a damage issue. Yes, no. Yeah, yes.
Properties I use for storage of my trucks.
Right.
One is gone. I'm still using the other one for trucks, right?
Right.
But not all the trucks.
Right.
So how is that a continuous use?
Because they're both used for the same unified purpose. The unified purpose is the test, and the only test.
They're not interdependent on each other. They're just.
Yeah, they are. No, I disagree. They are.
If maybe I see it a little differently. Assume that Mr. Pignetti has 8 large utility vehicles, and he uses both plots for parking purposes, because otherwise that area in Fishtown under I-95 is a highly regentrified area for which there is no parking.
Right.
So if one was confiscated, he would be unable to have the unified purposes that he has a protected area where he can store his personal property.
Absolutely.
Or business property.
Absolutely.
But by the confiscation of one, he's now left without parking for his 4 utility vehicles, subject to tickets, damage, whatever.
Right. And that is exactly what I believe Morris says. If they're used as a unit together, if you lose one of the, in that case, the 3 tracks, you necessarily injure it.
And is that the injury that he's claiming, or that's the continued use? So
Right.
he can store his electrical equipment?
Correct. And
I'm confused because I thought Morris talked about the injury to one constituting an injury to the other.
not in the analysis and not in its holding.
It does say it, though.
What it says is that if you lose one, not in the portion that is cited by the Commonwealth Court.
I'm looking at the case itself, though.
Okay, so if you go to the bottom of the column where I've got it, it's under 414764, those pages, and you go to the bottom, it says, if sort of midway through, if they're used together as a single enterprise, damages suffered thereby may be compensated. Where lands are inseparably connected in use, the injury to one must necessarily and permanently injure the other.
Yes, that's what I'm referring to.
And what I believe that means is exactly what Justice Doherty said, which is that if you need both and you lose one, you necessarily
You can't put all
impact the
vehicles
enterprise.
on the one property.
That's right.
Therefore, that property's injured because you're losing your professional equipment, is how I see it.
And you're not required to prove anything more other than the fact that, as it says here in the next paragraph, Chief Justice Todd, that the important element governing the basis for determination of damages in where non-contiguous tracts are involved, in addition to proximity, is the entirety of the use.
Yeah, but
It's the use.
Doesn't your argument apply to any two particular tracks? If I've got a particular tract of land that I use to store my electrical vehicles under I-95 in Fishtown, and I've got another one in Wayne, Pennsylvania, couldn't your argument equally apply? Well, I can't park the ones in Fishtown anymore, therefore you owe me for the one in Wayne.
So the law actually addresses that specifically, and it's not here. There's a proximity requirement. And it's not teed up here necessarily, though it was raised. It's been a little bit of a shifting argument by PennDOT over time. But initially, that was what one of their arguments was. There's a proximity argument. They have to be proximate to each other. Here, they're less than a mile. Well, certainly, the two are within 10 feet of each other. And they were less than a mile to the other.
Point, right near the music, the Fillmore.
Yes, right nearby. That's right.
Right out back. I know
Exactly.
the properties.
Exactly. So that would be solved by the proximity issue.
Counsel, Justice Doherty gave you a perfect setup.
Right.
And I agree with what Justice Doherty said.
Right.
You have a tractor trailer that requires either the width or the depth of both of the parcels in order to allow parking to take place there. And so if you lose one, you lose the ability of using the other lot because one without the other is useless to you. Correct. Because one lot will not allow you to park your oversized tractor trailer. That's not my understanding of the evidence in this case. My understanding of the evidence in this case is that there was no evidence addressing implications of losing one parcel or the other, or on the continuity of the electrical business.
Right.
This situation, as I see it, is you have trucks or vans or whatever they are, some of which are parked in one parcel, the other of which are parked on another parcel. If you lose one, you could still use the other for parking the other vehicles. That's the difference between what Justice Doherty described and what my understanding is of what we have here.
I agree with you factually, but not legally. I agree with you factually. Legally, that is not the test. The test is not the damage to the other. Nowhere in 705 does it say you have to prove the impact, right?
No, but it says a unified purpose.
Right.
Not the same purpose, because the General Assembly knew how to use the word same. They used it in the preceding part, which says the same, substantially the same ownership. It then goes on to say which are used together for a unified purpose, not the same purpose.
Right.
So the two parcels of land had to be unified in a purpose. And Justice Doherty's example is you're parking oversized tractor trailers. That absolutely requires utilization of the two contiguous lots. That's a unified purpose. That's not what we have here.
Again, I disagree with that factually.
Okay.
They were used for a unified purpose, depending on your definition of unified. If you take, for example, what Morris said, which is if they're used as a unit, okay? If you say that that's what unified means, they were used as a unit. They were both integral in the operation of the electrical business. They were both needed. You know, could they have been replaced? Maybe, but that's not the issue. The issue is how were they actually used and what was the purpose for which they were used. And they were used...
That makes sense. I mean, then it's not a unified purpose. Let's say that the contiguous lots were used, one of them was used for parking.
Mm-hmm.
And then you skip over to the other lot and that's used for storage. That's in no way, shape, or form a unified purpose. They're two different purposes. One is for parking, one is for storage.
For the same business?
What difference does it make, same difference or not? I mean, they're totally different uses, let alone a unified purpose.
Sure. So, for example, the Morris case, they were used for a farm. And the farm used different components. So, to your analogy, one would be for parking and one would be for storage, but they were both there to support the farm.
No, but the one in the Morris case is exactly what Judge Donahue was talking about. The Morris case, the tract that was being taken was a dairy farm, and there were sheep and cows. The one tract that was being taken had the stream through it. So when they took that tract and the sheep in the farm could no longer access the water, they said, well, you can no longer use it as a sheep and dairy farm because they have no more access to water. Therefore, it's an interdependence of use. In other words, the use of the grazing pasture is directly dependent upon the water access, which is being taken away. So you can no longer use them. In this particular case, if we take the one, you can still store your vehicles on the other.
Right, but you may not be able to support.
That's what Justice Donahue mentioned.
But you may not be able to support the business. And what the Morris Court is saying, which I think is the correct way to look at it, is if you have tracts that are used together and you take one or two away, you have necessarily injured the entire enterprise.
You know, Mr. Snyder, the more you talk, the more you're convincing me. I'm starting to see it
It's
your way.
very typical. It's very difficult.
Because if you have a business, and maybe your business relies on having easy access to all of your parked vehicles and having access that your employees can go out a door and have them all right there, maybe that is injury to the other if it's injury to one if they're not together.
Right. And I think it's frankly, I think it's a very low threshold. Now, down the road, when you get to the board of review and the trial, you're going to have to prove what the amount of it. But this is just simply a ticket to say you have to value these two together.
Well, but counsel, I think that's important because we have to think down the road of how this is going to work. Are you saying that these two properties, these two non-contiguous properties, which at one point in time were one lot, correct?
No.
Oh, I thought that there was an earlier taking.
No, the city actually owned they're all irregularly shaped.
I didn't mean to inject something that made it more confusing. But are you suggesting that when this goes to the Board of View, that the valuation of these now together for a unified purpose lots includes this third lot somewhere where the business is located?
No, just the two that were taken.
Then how do you possibly litigate that valuation without considering the impact of losing one to the business?
Sure.
Because you can't value the impact of losing it to the other, because every time every justice asks you that question, you keep going back to the impact of the business, which is a lot we're not even talking about.
Right.
So how do you do that?
So first of all, again, if you look at the clear wording, was it used together at that time for a unified purpose, right? At that time. Now, you may, as I think maybe either Justice Doherty or Justice McCafferty said, Fishtown section is going nuts right now in terms of development. You could change the highest and best use. I'm not suggesting you would or you wouldn't. All I'm saying is that this section requires, if you check the boxes, which we do here, that they have to be valued as one. Now, if PennDOT wants to come in later and say, and I know Judge Robson, you know this from your time in the Commonwealth Court, that if it's excess land or surplus land or something else, and therefore it's got a de minimis value, okay, we'll fight that out later. But for now, the only question is, do you check the boxes of the clear wording? And the clear wording, I guess we're focusing on the word unified.
Well, I'm not going to belabor the argument, but I actually think that your bigger issue is the word together. But that's
okay.
I think you could arguably say it was unified in the sense that they both used it for the same purpose.
Right.
But the question of the togetherness, to me, is kind of the issue: is were they together or were they separately doing the same purpose? Like what was the creating?
Oh, okay.
What was the creating of the togetherness?
Well,
this is really what. But I don't want to. I've been a little off the wall today, so
I just want to raise one or two other things before I move on, and of course answer any other questions the court has. But I just want to raise one other issue when it comes to the applicability of Morris. I think it has to be read in conjunction with Werner, which is the only other Supreme Court case that's addressed here. And what's interesting about Werner is, although it was decided just after the adoption of the code, it was a pre-code case because it was filed before the code. And it goes through a little bit of an analysis. And it says, and of course it cites to Morris, and what it says is that we're not going to address the issue because the record wasn't properly preserved. But the most interesting part of Werner is it says, quote, the doctrine is still in its infancy. Now, it cites to Morris, so this is after Morris. It says the doctrine is still in its infancy, and the outlines of the doctrine have not been spelled out. So Werner's saying, okay, we got Morris, and we may have some other cases, but we're not quite sure what this thing really means yet. And I think it was answered by the General Assembly when it enacted 705. So to the extent that you're looking at who's right here, for lack of a better way of saying it, you look at the plain wording of 705, and maybe we have different definitions of things and we're going round and round on words, but I think that, in my opinion, a reading of it is that 705 replaces anything before it, number one, and number two, that you have to just check the boxes, which I think happened here. I will also say one other thing before I move on. Courts have specifically said in many contexts, in essence, the statute should be liberally construed for condemnees. In this case, for the property owner. And in this case, they've explained that the purpose of Section 705 is that the condemnees receive just compensation, and that therefore it must be liberally construed to affect its object and produce a just result. I under any way you look at it, I don't think it's at all possible that someone would have come in here and bought one without the other. They would have bought them together, and as a result, if you're trying to say what would have happened in real life, what is a just compensation here, they have to be valued together. So unless there's any other questions on that, I'll just very briefly get to the ownership
Can I
part.
just ask one point? Is
Yes.
there something in record that says no one would have bought these separately?
No.
Okay.
What is on the record is that there was discussions at one point of developing this that got thwarted because of the threat of the taking, and that they actually have put some plans together to develop it. And they would have been just like that. One would have been, assuming it would have happened, one would have been for some kind of residential development, and the other would have been for parking. So, briefly on the identical ownership. First of all, the Commonwealth Court chose not to address this. It was just addressed by the trial court. It's undisputed that the condomnees were the sole record owners of the parcels, that they paid the taxes here. Now, PennDOT claims that it has an unrecorded easement over parcel 45, precluding the application of 705. As the trial court said, PennDOT fell, its words, woefully short in proving that it had that interest. Now, first of all, PennDOT admits it can't produce a document establishing the alleged ownership. There's no declaration of taking, there's no deed, there's nothing else that conveys what it claims is an easement right to the property. Instead, it cites highway plans from 1966 and the 2010 deed. Neither creates a property interest. The plans are just that, plans. They don't create interests, they're just plans. So that, and they don't allege that in any of their briefs that created an interest. Similarly, the deed doesn't say that there's an easement. It doesn't say subject to an easement that. Instead, there are times when it references the Delaware Expressway, but it's merely, and right-of-way lines, merely because it's using it for a meets and bounds description to say what the outline is. Now, even if PennDOT has some kind of easement rights, it has the burden to prove that these rights preclude application of 705. Since they can't prove the nature of the alleged interest other than them saying, take my word for it, they don't meet their burden. Section 705 does not require exact identical ownership, only substantially identical ownership, and it was amended in 2006 to add that to give flexibility to the courts when addressing this issue. In this case, the only one that owned the parcels were the condomnees. They're the record owner, and there's no recorded document of any interest. What PennDOT, even if they have an easement, that doesn't mean they have an ownership interest in the property. It means they have easement rights to use part of the property, and those are two distinct issues. Also, even if they have that easement, it doesn't mean that it defeats the substantially owned portion. At most, what they have claimed below, although again it's a little bit of a shifting ground, that they have an aerial easement which permits parking. That would not defeat either the current use, the then current use, or any other future use to the extent that it would have parking, and PennDOT has said, we're good with that. We're going to allow people to use the property other than where the actual cement is. And then lastly, I want to say that if you were to believe and accept their argument that these easement rights defeated it, it would lead to absurd results. There are any number of properties that have easements on their property, whether it's a utility easement or some other kind of easement. That would mean that every single time that the electric company came in and got an easement for lines, you could never apply 705. That was not the intent. It's substantially identical, and it's clearly met here as the trial court found.
All right, thank you very much.
Thank you.
Let's hear from Mr. Boyer. We always like to close court with an eminent domain argument.
Don't we all? Madam Chief Justice, may it please the Court, Jacob Boyer on behalf of the Department of Transportation. I would like to begin with questions that I believe Your Honor, Madam Chief Justice, and Justice Brobson were asking about the electric business and its import here. I believe Your Honor said you were persuaded by some of the relevance there, or moving in that direction. Yes. So I would like to start there and then move to Justice McCaffrey and Justice Donohue's question about the text and history, which I think hit the nail on the head on both respects. The electrical business and the relationship between the storage fields and the electrical businesses is not a part of this case. The argument here, and the only argument that appellants have made, is that the two parcels themselves meet the standard. Had they wanted to argue that the electrical business was also a part of the unified property, that would have needed to have been raised in a declaration, or excuse me, preliminary objections to the declaration of taking. And we would have, in that situation, been in a much more common posture where this issue comes up, where there's a condemnation of one parcel, the owner says, actually, you're incomplete, there's this other parcel over here that's unified, you need to factor that in. That would have been the argument they would have needed to have made with respect to the electrical business.
Well, I guess what threw me off there is I thought Mr. Snyder was arguing that these two parcels are unified in their service to the electrical business.
I think that is the argument he was making today, and I don't think that's a proper argument to be making, is my point. Their relationship to the electrical business and whether the electrical business was a part of this analysis explicitly under Section 302 would have been needed to have been raised as a preliminary objection to the declaration of taking, because it is an argument that the description of property in the declaration of taking is incomplete because it fails to account for the effect or the implications on the electrical business. But that's not the argument that's being made here. The argument instead is that the two fields themselves, irrespective of the electrical business, satisfy the standard. So the electrical business is, again, beside the point. Turning to...
But I'm sorry to dwell on this, but aren't the vehicles parked there because they are in service to the electrical business?
They are, I believe. I don't think that's not been the focus of the testimony. The testimony has been, and the argument has been, they satisfy the standard exclusively because of the relationship between the two storage fields, independent of their effect on...
This was easier when we were talking about dairy cows.
That's right. And so, and again, that would have been, had there been an argument that the electrical business was a part of this, we would have been in a much more common situation with Section 705, where there's an argument about the description of property being complete or not. Moving then to the text and the history, I do want to reiterate, I think Justice Donohue, Justice McCaffrey, you were exactly right in your understanding that same and unified are not interchangeable concepts. The ordinary meaning of unified as a matter of plain text is that the two things that must be unified together, as you mentioned, Justice Brobson, have some effect on each other such that the taking of one parcel will impact the other parcel in some demonstrable way. And that simply has not been alleged or shown here. Rather, throughout, what appellants have tried to do is replace unified with same and sort of say it's enough that they're the same, but that is absolutely not the meaning of unified for together. And not only do you get there from the plain text of the statute, but there are three at least compelling points that communicate that the ordinary reading of unified is the correct one in this situation. The first of which is the reference to Morris. And respectfully, I do disagree with my colleague's reading of Morris. I think the essential component of the court's decision there was that the taking of the one piece of the farm affected the entire business. The court's rationale was it affected their access to a stream, he had to reduce capacity at his barn, his herds didn't have the same pasturage, and on page 415 of this court's conclusion, it says the loss here consisted of pasturage and water, and he had to reduce his operations and the size of his herd and the consequent uneconomical use of barn and storage facilities. So it absolutely was about the effect of one on the entirety.
That was a pre-code case, right?
That was. So what?
So they couldn't have done what you're arguing should have been done here, which is bring the business in by filing a PO and claiming that you're taking more. Because that sounds like, in that case, that sounds like they were saying you're effectively taking our other our entire farm operation.
So I mean, the procedure may not have been the same, but in Morris, they did properly raise the argument, and the court ultimately agreed, yes, we agree that the taking of this finite piece of land does infect the entirety. So it may have been a different procedure now, but they did exactly what should have been done to make clear that by taking some sliver of land, you are actually affecting a much bigger tranche of land. So, and in 1964, the Joint State Government Commission explicitly says we are meaning to codify the decision of Morris. And respectfully, I think the ways in which my colleague tries to limit that are unfounded in at least three critical respects. One, it doesn't really make much sense to say all they were trying to do with the reference to saying we're codifying Morris is to identify that there are some circumstances in which non-contiguous land should be valued together. The text of the statute does that. The reference to Morris in the codification is entirely unnecessary for that purpose. There's also nothing in the comment itself that says we are limiting this, but we mean to adopt Morris, but only for this narrow idea that some non-contiguous land can be valued together. And third, the focus of Morris was not are there situations in which non-contiguous land can be valued as one, it is what are those situations. So to say and it reviews case law that precedes it. So to say we are codifying Morris when Morris was explicitly about not can this happen, but when does this happen, that's the proper way to understand.
Counsel, did you just say we codified Morris?
Well, the commission, let me just read exactly what the commission said. The Joint State Government Commission, which is again composed of the General Assembly, says this section codifies existing case law, citing Morris. So that's directly.
So here's the question I have. So it's your position that 705 is ambiguous, such that we have to look at the comment in the legislative history? Because otherwise, we just look at the plain text.
No, Your Honor. I think the plain text here resolves it because the ordinary meaning of unified together for a common purpose is that there needs to be some relationship between parcel 44 and parcel 45, such that by the taking of one has an impact on the other.
That definition is what you're deriving from the Morris holding.
No, Your Honor.
Unified purpose means unified purpose. We're sharing a common interest.
No, I think unified purpose, and we cite this in our brief, three different definitions of unified. Unified denotes some togetherness. There needs to be an effect from taking one on the other. It doesn't just mean same or similar ways, such that parking satisfies the standard. Unified, as a matter of plain text, does mean there needs to be an effect on one from the taking the other. So I do think the statute is unambiguous. If the court believes there is ambiguity, I think Morris, the language saying the section codifies existing case law, makes quite clear what the General Assembly was intending to do. Again, I don't think it's necessary to reach that. I think plain text resolves it. Two other.
The General Assembly's reference to Morris in the comment to Section 705 was when we talk about unified use, this is what we're talking about, what the court decided in Morris. They used Morris as an example of unified use.
I think that's exactly right. Just remember, yes.
In other words, taking the one property eliminates the entire use of all the other contiguous properties.
Or at least affects it, has some effect. I think that's exactly right.
Unless that language was incorporated into the statute through the numerous amendments for which it was not. It's language from a 1951 case that was never included in the 64 Amendment, the 85 Amendment, or the 206 Amendment.
Well, all of those cases speak to unity of use. So I do think this concept of unity does carry out through all the pre-coded cases. I think it is an ordinary understanding of what it means to be unified. So I think you get there as a matter of plain text. If you don't believe plain text gets you all the way there, Morris is one piece that you can look to that gets you there. Another key piece would be the history of the eminent domain code. So obviously this language was part of the original code in 1964. There's a 1968 decision of this court, Sams versus the Kensington Redevelopment Company, that when it articulated what the 1964 standard was, it repeated the same language as Morris. It said there needs to be two pieces to this. There's an ownership piece and a unity of use piece. The Commonwealth Court several times between the Sams decision in 1968 and 2006 repeated that standard, and critically, in 2006, when the General Assembly amended the eminent domain code, it modified the ownership piece of what Sams said, but not the use piece. I think that's further evidence that from the General Assembly's perspective, the case law from 1968 and the series of Commonwealth Court decisions have
Counsel, let's be careful. Wasn't it Oliver Wendell Holmes who said It's not what the legislators meant, it's what the statute means. So we only get to what the legislators meant if we don't understand the meaning of the statute.
Yes, Your Honor, as I said, I believe the statute is quite clear. I am offering reasons why, if you have doubts about that, I'm offering you reasons why you would get to the exact same place otherwise. And the last piece I want to address is just compensation and the purposes of the eminent domain code. I agree completely with my colleague that the purpose is to offer just compensation, and this section identifies situations in which land, despite the fact that it is non-contiguous, should be valued together as a single parcel. To replace unified with same in an effort to effectuate that standard would lead to unjust and sort of absurd results. As Justice McCaffrey, you identified, same could be a standard where these parcels are on opposite ends of the block, which I think, as a matter of proximity, would be close enough, but really would have no relationship to each other. Same could also create problems about how close is same, how same is same enough. 2 parking lots, but one's residential, one's commercial, 2 parking lots, one used intermittently, one not. It leads to results that can't be administrated and in many cases would be unjust. If there's no further questions about that piece of 705, I will turn quickly to the substantially identical ownership piece. And I would like to correct one thing my colleague said about what the Common Pleas Court said. The Common Pleas Court did not say PennDOT fell woefully short in establishing the existence of the easement. It made a legal conclusion that it basically said whether the easement exists is neither here nor there, because as a legal matter, the easement doesn't make a difference. And on that point, it concluded as a legal conclusion that it was woefully short in establishing that with the easement 705 was defeated. The easement at issue here is not an ordinary easement. It is an aerial easement for highway purposes that gives and it entirely subsumes parcel 45. So this is not an ordinary easement, a utility easement, an overflow easement. There are a lot of different easements that have less heft than the easement at issue here, and also cover less of the landscape of the parcel. This is a parcel that is entirely subsumed by the aerial easement, which gives, it's not a simple interest, but courts have described it as sort of a conditional fee in the land that allows PennDOT to use the land as needed to support the highway that runs above the land. Parcel 45 is entirely beneath 95. Parcel 44 is not, which is why, from our perspective, they don't have substantially identical ownership. I think my colleague was exactly right in his brief to say ownership is a flexible standard, and when you look at is how the land can be managed and used. There is nothing that can be done with parcel 45 without the Department of Transportation's approval. It needs to make sure it's safe beneath there. I think recent experience shows the importance of keeping things safe beneath bridges. So there's nothing that can be done there. The ability to manage and use that property is subject entirely to the highway easement that existed. So the management and use of parcel 44 and parcel 45 are not substantially identical. And unless there are any
other questions? All right. Thank you both. Very well argued. This concludes our 2024 spring argument sessions. I would like to thank PCN for televising our arguments and providing that educational opportunity to the public. I'd like to thank our court crier, Brian Minner, our prothonotary, Caitlin Gorman, and our court security, Gary Shovlin, John Evans, and Scott Town, as well as the Capitol Police. We appreciate your services. Mr. Minner, you may adjourn the court.
Okay, shades of whack.